Do you? Use that one. Yeah, that'll work. That'll work. HDMI cable.
All right.
No, it's fine. We'll be fine. We'll be fine. We'll put thank you.
Ek het graag die presentations. Wie is so wat dat die
Ons doen alles uit kan. Maar nee, los het ons op maar. Alles dan vergeet ek.
die full charge.
Ja. Ja, is 100%. Kijk, 84%. Ja, maar ik eet my.
No, but we can take a long time.
Ek gaan maar net vir jou folder maak.
Ja, so over hier by desktop.
Thank you.
Hierdie is nou steeds is my presentasie. Ons lyk nou gebou.
Good morning, ladies and gentlemen. It is, what's the time now? 8:54. We will start now. Otherwise, we're not going to finish by our time that we're supposed to finish. I find that usually around 12, then the energy levels start dwindling, and that's the time that I usually do my last presentation, and everyone else run away, and then my wife is the only one listening to me. My wife is not here today, and I'm not going to sit with an empty auditorium with just talking to myself. So because of that, we will start earlier. I just would like to first of all start and introduce some of our honored guest speakers that is over here. Our guest speaker, Advocate Mohammed, is already over here. Can you just stand so that people see who you are? That is our guest speaker, a person that's making big strides in maintenance and family law legislation. And if you go on Safely and you put his name in, you'll find a lot of cases that he's done groundwork as far as changing the South African family law, even with the J. Peterson case, where it was for the first time established and accepted that parents can, grandparents can also be held accountable, and that is the gentleman that brought about that change in law. There are some other cases that he is involved in all over South Africa, and him as well as his colleague Nicole will be talking about it a little bit later. I also would like to then just welcome the other members and founding members of our Maintenance Community Dialogues, Felicity Guest. She is the founder member of the Child Maintenance Difficulties in South Africa Facebook website, and she will do a further presentation on the Potgieter case that we dealt with at our last presentation in April, so she will have an opportunity to do that. Mr. Eugene Opperman is going to start off our session today with the rights and recourses and what people or applicants should do or can do in maintenance matters. I just want to also introduce my one colleague over there. So if you're going to complain today about maintenance officers, don't complain to me, complain to her. Nokwanda Ozani, she is my colleague and the maintenance officer in Wynberg Court. The other colleague couldn't come this morning. He's sick. His name is Lucian Arense. He will not be here today, as well as our Belleville representative, Mrs. Roxanne Jansen. She will also not be here. We've got some other esteemed colleagues over here from Elisaio now, and they were part of NICO. NICO is one of the organizations, NGOs working in the field of child justice. Arina Smith, can you quickly just stand so people see who you are? Next to her is Ibtisam Peck. Ibtisam is also a colleague and a social worker in the field, and two esteemed colleagues that I had the opportunity and at least the privilege to work with, and that I took the Child Justice Act as well as the Children's Act to Parliament with the help of the two ladies over there in the back. In front is Marie Fourie Strijdom, or Marie Fourie, I don't know how many others. Marie, can you quickly stand? She's also an esteemed friend of mine, an attorney at Howard, and also very much involved in the field of family law. So in case you would like to get a cheaper version of the advocate sitting over here, then you can speak to Ms. Marie Fourie, because advocates come at a very high rate. So I'd rather go for a cheaper option first and get your briefing to her, and then hopefully she will get a cheaper advocate for you to assist you in whatever your case might be. I'll stop there. There's some other people that will come later. Don't worry, if you leave by 12, my wife will be here, so she will listen to me. So at least I will have one that will be listening to me. The program for today, Mr. Eugene Opperman will start off with the rights and recourses. Then Ms. Felicity Guest will do a presentation on the further deliberations on what should have happened in that Potgieter matter. We heard the video recording of Ms. Louise now last time and what she's gone to in the system. And today, what should have been the response of the Department of Justice as well as the National Prosecuting Authority acting in maintenance legislation. The esteemed advocate will deal with the case that he dealt with in the Eastern Cape, dealing with the court orders that is made and how the courts or the magistrates will interpret the provisions in Section 16, but without actually applying Section 16, but the briefing attorney as well as the advocate will give you a good rundown of the PM case that they dealt with in the Eastern Cape. And I think it is a good lesson, especially for our maintenance officer here, that she can say, but this is the consequence of the actions of the magistrate in making the Section 16 the fair and equitable decision in cases of maintenance matters. I will end off the session with my continuance of civil attachments. We dealt with the Section 26, 27, 28 in April. So I will finish off with Section 30, attachment of debt, as well as with the provisions as far as future maintenance is concerned, and I'll give the case law dealing with it. I will do cross reference to certain pages in the handout. I hope all of you got a handout. Those of you that don't have a handout, there are handouts in front. Make sure you've got a copy of the handout because I will do a lot of cross referencing. Mr. Eugene Opperman's PowerPoint presentation is also printed, so it is in there, so you can follow what he will be doing. My presentation is always at the back, so you will always be able to then follow in there or make notes on it as we go on. And then you will be able to get as much information that you can today. The online people, we did make the handout available electronically, so they will be able to follow electronically whenever we start going to all of that. Just the logistic arrangements. I hope all of you park in the parking bays reserved for public prosecutors. If you park on the outskirts or in the middle of Bay Street as well as Leeuwin Street, you will be charged 28 rand an hour. So we'll be sitting over here till around 1:30, 2 o'clock. So it will be at the cost of at least 150 rand in case you are not parked as a public prosecutor or in the parking bays reserved for public prosecutors. There is also catering facilities available in our cafeteria. If you want to have some coffee at a nominal charge or want to have a light meal as from 10 o'clock, you can then go to our cafeteria. I will make a list available of what is available in the cafeteria. Please do not eat in the venue. I had a session with our security and management and they do not want any eating or drinking because on a Monday morning this venue is going to be used by other people, and if the place is dirty then I get the brunt of it and I'm getting the venue for free. So please can I just ask that if you want to eat or drink, use the demarcated cafeteria for that purpose. There is also a patio where the smokers can stand and smoke and have a beautiful view of Table Mountain. So please go and enjoy the view and help me not get into trouble with our security and risk management on Monday morning. by us eating or drinking in the venue. For those of you that do not have any funds available, there are free coffee that is available over there in front. Those of you that do have a few cents in cash with you, you can go and buy coffee, tea, or Coke, or any of the other things that's in our cafeteria. Okay, that's what I wanted to say. Toilet facilities on this floor and next to our gym. Yes, we do have a gym, even though I don't look like somebody that's been to a gym. The gym is next to the cafeteria. Next to the cafeteria, there is also a toilet for females and males, in case some of you would like to use it. If any of you need any other information, please go on our website, www.childmaintenance.org.za. If there's anything that we're talking about today that you'd like to have a copy of, please email us info@childmaintenance.org.za, and we will send you whatever we are talking about. Just make a note, just don't say no, that's what you were talking about. Please be specific. If it is a case, please tell us what case it is that you're looking for. If it is a form J306, then please just be more specific, and then we will be able to send you any of the things that we will be talking about today. Without further ado, I will give over to my colleague, Mr. Eugene Opperman, and he will deal with rights and recourses for applicants in a case where they file the maintenance application, or they are at the maintenance court and they don't get the assistance, or they get a rude maintenance officer to deal with. He will tell you how you deal with that specific person in case you are aggrieved by that specific person's attitude towards you. So over to you, Mr. Eugene Opperman.
Thank you, guys. Welcome from my side as well. For you guys to be here on a Saturday morning and offer up your time, it actually shows commitment that you are willing to learn and to tap on our knowledge that we so freely give. Like Advocate Reiter said, yes, we will be talking about the rights and recourses. What is your rights in terms of a maintenance, in terms of the Maintenance Act? We will be speaking about the DOJ Code 26 of 2015 and just the complaints procedure. Once you have rights, if you have a right in any event, there's always a complaints procedure that needs to be followed. And then we'll briefly talk about the reviews and appeals on maintenance matters. And that would lead into Advocate Mohammed's talk about the case that he did, and as well as Advocate Reiter's his presentation with regards to civil attachments, and then ending up with Felicity in continuance of the Potgieter case. So yeah, rights and recourses when it comes to maintenance. It's big words, but what does it mean? My experience the past week with regards to maintenance, maintenance courts, maintenance officers was one of absolute pure frustration. And then I looked back and I started reading up on, you know what, where did it all start? I'm not going to bore you with some details of where did it start and what was the origin. It all started off, let's start off as a starting point with the Maintenance Act that came into operation in 1998. And soon afterwards, there was a case of Ballantyne versus Ballantyne. And in that court case, and that was just after this miraculous Maintenance Act was enforced or enacted, where the court said that despite the good intentions embodied in the Maintenance Act, logistical difficulties in maintenance courts mean that the maintenance system does not function properly or not effectively. How true is that? That was a constitutional court ruling that was handed down in 2002. That was shortly after the act was enacted, the Maintenance Act was enacted. So then by that time, they already realized that something's amiss. Something is wrong, something is not right. And then afterwards, in 2014, quite a number of years ago, quite a number of years after the Ballantyne case, there were submissions done to the South African Legal Reform Commission. That was a document, Project 100, and it was an issue paper 28, where they submitted to the South African Law Reform Commission lists, documents, recommendations on how to change the maintenance system. And I'll give you a couple of examples in a minute. After that was done in 2014, the bottom line there was, you know what, the Maintenance Act is in serious need of a revamp. I'll get to that in a moment. Subsequent to the paper that was issued by to the South African Legal Review Commission, they listened. For some weird, wonderful reason, they listened. And then the Maintenance Amendment Act was done in 2015, and there was amendment to the regulations in 2017. So now you can see the long process that it takes. From 1998, when the Maintenance Act was enacted, up until 2017, when something was done. Only then. Isn't it about time that we change it now? So yes, frustration. I can give you a couple of examples of my frustration in court just today, or not today, during the course of the week. I was at a local magistrate court doing an ex parte, and Dylan will emphasize on that with civil attachments. I did a ex parte application in terms of section 27, and then the magistrate in front said that, you know what, it is his belief. It is his belief that the respondent needs to get notice of a warrant of execution to be issued. So I said, you know what, with all due respect, Your Worship, we're in a court of law, not in a church. Keep your beliefs out of it. You've got a certain set of rules that you need to abide by, and that is the Magistrate Court Act. You cannot go on beliefs. So we entered into a very heated argument. I'm accustomed to screaming at people in court, be it a magistrate, be it a maintenance officer, be it opposing parties or whatever. So I can raise my voice and I can get quite passionate, because I am. You know what he said? He said, you know what, that's it. So I referred him to a case that popped up and was ruled upon 3 weeks ago, where the High Court actually said in the VDB case, where it said that, you know what, it could be done. And the magistrate looked at me and he said, but you know what, if you know so much about maintenance, why don't you become a maintenance officer? I nearly lost it. I nearly lost it. That was our frustration. Then I also have a Facebook group, same as Felicity, and we have a WhatsApp group and everything, and we attend to the queries of people, of mothers standing in a queue, waiting to be helped at certain courts. And you know what? They're not. They don't get any joy. Poor Advocate Raiders is sitting at 10 o'clock at night, 11 o'clock at night, sometimes 2 o'clock in the morning, and he answers WhatsApp messages, trying to assist people, just because the system is not working. So frustration, yes, absolutely. In the paper that was issued to the South African Commission in 2014, some of that, I just want to highlight a couple of things that they discussed there. Number one, they said they should be investigating Saturday courts for maintenance and other related matters. Hallelujah. Isn't that a brilliant idea? But you know what? What has been done since 2014? Nothing. Nothing. We still don't have courts on Saturdays. We still don't attend to people after hours. Urgent cases, we still don't do that. Introduction of mediation services for maintenance matters. Has that been done? No. Facilitating skills training for maintenance, line managers and frontline personnel. Has that been happening? No. We still get rude people. We still get people, maintenance officers, maintenance investigators, maintenance clerks, being rude, being disrespectful. Appointing of additional maintenance investigators over a period of 3 years. Not one was appointed. Not one. Why? Because the government doesn't have money. They don't have money, but they've got 22 million to spend on flag. But they don't have money to allocate towards maintenance. And the list goes on and on and on and on. That was in 2014. And then I started, just to add to my frustration and my aggravation, I started reading up on the strategic planning. The strategic plans of the DOJ since 2014. And if you ever wanted to read up on a horror story, do that. because they started off very nice. They started off with brilliant ideas. 2014, 15, 16, 17, 18. They all mention all the problems. They just regurgitate each and every time all the problems of the past, but nothing has been done to it. On the latest one in 2020 to 2025, there was only mentioned 6 times of maintenance. 6 times maintenance were mentioned. Sure, they jumped on the bandwagon of GBV and they tried to mask that, and they tried to incorporate maintenance to dilute maintenance and focus more on GBV than maintenance, which is wrong because it's 2 different issues. The one leading to the other one, they're all intersected. Yes, most definitely. But don't try and dilute it from a GBV side. On the strategic plan in 2020 to 2025, this was quite interesting, where they said that maintenance and other issues related to children are of a major interest to the department, right? While major improvements have been done in the process related to maintenance applications, the department plans to improve speed and efficiency in finalizing maintenance orders. Really? Really? What has been done? What has been done with regards to this? This was published in 2020. What has been done in 2 years' time? Nothing. Nothing. The problem that we set now is that, you know what? You can sugarcoat a piece of shit, but you can't call it a chocolate. Do you understand my frustration? That is what we are being dealt with at this stage. Sorry about my swearing. I get passionate. I get angry. I get angry. And you know what? Education is knowledge. We should educate ourselves like we do right now. We should know our rights. We should know what is our rights, what are recourses, so that we can take those type of people to task, hold them accountable. I've been in the office of a maintenance officer, which not in the area, it's a little bit farther up. I'm not at liberty to say because the case is still pending. And you know what she said? I stood in and I listened to a conversation between her being rude to a complainant. And she said, but you know what? And the complainant actually said, you know what? I'm paying your salary, so you should listen. Okay, the comeback on that was, you know what? You're paying my salary, I'm due for an increase. Okay. So that didn't work out quite well. But that is the mentality that we have at this stage in the courts. And that's totally wrong. Totally wrong. So what is the action plan? We do have activists, a lot, fighting for maintenance, fighting for children's rights, fighting for rights of mothers. That's on the one side, and they should take on government. But to take on government is like fighting with both hands tied behind your back. The other way that we could do it, we should have a 2-pronged approach, from the bottom up and from the top down. From the bottom up is the normal public. It is you and I. It is the attorneys. It is the complainants. We need to know our rights so that we can tell the maintenance officer, and we will be able to stand up and tell the magistrate, you know what, I do not agree. I do not agree with this ruling because this is the law. This is what the DOJ Code says. This is what the regulations say, so that you can stand up on your rights. And as soon as you do that, they start backing off and say, but you know what, listen, you know what you're talking about. That is what we need to do. We are in the process, childmaintenance.org.za, we are in the process of creating a complaints forum where complaints could be submitted via the portal directly to courts. My aim, my personal goal for the end of this year is to have 80,000 complaints. I don't want to print it out in 27 boxes. I don't want to dump it at Parliament. I'm going to tell them, listen, you attend to these queries now because you're not doing anything. That is the goal. That is the goal that we want to do. So like I said, there's an action plan. Do it from the top, bottom, and to put strain and to put the responsibility on government to listen to the public. That is what we need to do. But it all starts with us being here, listening online, trying to educate ourselves so that we know what are our rights, what can we stand up for, and then proceed from there and make a change in your own case for that to go further. There's a couple of basic rights. You've got your first generation rights. Those are the rights that actually protect us, the public, from the abuse of the state or other powerful entities. And those are freedom of association, freedom of speech, freedom of religion. Those are the first generation rights. Then you also have the second generation rights, which are also called the positive rights. Those are the socio-economic rights, which requires the state to provide something. Examples of that would be the right to healthcare, sufficient food and water, right to education, right to access to courts, and so forth. And then we look at section 28 of the Constitution. Maintenance, although it is a gender neutral format, because in layman's terms, we say that we talk about the applicant or the complainant as the mother, because about 98% of it is so. The mother is the complainant. But it is gender neutral, because I also have clients that are dads wanting to claim maintenance from the mother. It happens. It happens. Paramount to all of this is the best interest of the child. It is all about the rights of the child, which is found in section 28 of the Constitution. And the child has certain rights. We're talking about rights. We're talking about rights of you as a parent or the parent. But there's also the rights of the child. And the child has a right to family care or parental care, basic nutrition, shelter, healthcare services, and to be protected from neglect and malnutrition. Those are all the rights that the children have. It is also contained in a statutory provision in terms of section 15 of the Maintenance Act. So that the legislator actually went further and he said, but you know what, apart from the basic right that you have in terms of the Constitution, it's also enacted in section 15 of the Maintenance Act, where it says that a maintenance order could be obtained for the maintenance of a child, and it is directed to the enforcement of the common law duty of the father. The father has a common law duty to support his offspring. If he likes it or not, that's his common law duty. And then section 2, subsection 2 says that, you know what, this basic rights of this child includes proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. It's not something that you have to beg for. It is not something that you have to stand in a queue for months on end at a magistrate court begging to be helped. This is your right. This is what you can expect. This is what you can put in your complaint as the basis of your complaint. So like I said, once you have certain rights, you also have a complaints procedure, because you need to enforce your right. And there's a clear distinction between a legal recourse and a non-legal recourse. What is meant by that? One should remember that the judiciary, the magistrate or the judge listening to your matter, is exercising a judicial discretion in terms of the law. And that is protected in the Constitution, the unbiasedness of the courts. So we have to distinguish between what is done in court and what is done outside court. So there's a process that the maintenance officer follows, the maintenance investigator, the maintenance clerk. That's separate from the orders that the magistrate gives. And your recourse and your rights of complaint differs between the two. So there should always be a clear distinction about things that happen outside of court and things that happen inside of court. Just bear that in mind. We'll come back to that now. Now, let's talk about the process of complaints. You'll find at all magistrate courts, there are boards put up like this on the slideshow. And it indicates the court manager, the area court manager, the director of the court operations, and also the regional head. I would urge people listening online, people sitting here, if you have a maintenance matter pending, the first thing that you should do is take a photo of that. Take a photo of that board, because I can guarantee you at one stage you'll need it. Take a photo thereof. Take your cell phone, take it out, take a photo. We are busy compiling a database of all this information countrywide. And that also links up to our complaints procedure. We would ask you guys to WhatsApp that photo to this number there, or to email the photo thereof to info@childmaintenance.org.za. The reason for that is so that we don't have to contact each and every court again to duplicate that, so that we expedite the process. So if you do have that, all over, if you're attending to court, if you need to be in court during the course of the week, please do that. Send it through to us. We'll attend to that. So what is the complaints procedure? Now you're at the magistrate court, what is your first recourse? You need a format or a way to complain. So the first line of defense would be the court manager. That is the person responsible for the general workings of the court, and it's basically an administrative post. If you do not get any joy from the court manager, you can escalate the matter to the area court manager. No joy there, then send it through to the regional head. If you still don't have any joy there after a period of time, then you can send it through to the national office, the complaints manager at the Department of Justice. Or you can employ the services or ask for the intervention from the public protector. Now, a while ago, we started off by making available a portal where that you can lodge your complaint directly to the public protector. They were inundated with complaints. They had about 400 complaints within a couple of days. So that is the seriousness thereof. Our suggestion would be to email, because now remember you have the details of all these people, the court manager, the area court manager, as well as the regional head. You have beforehand, because you've taken the picture at court. So you have the details, you have the email address. So what we suggest is that you email those complaints. Just don't hand it in, because you need a copy. You need a trail of evidence to prove that you submitted those complaints, to follow the hierarchy of complaints. Because like any other justice system or any government system, they work in terms of hierarchy. The one is just more important than the other one. They all get the paycheck from high above, but they just feel in terms of the hierarchy. And I've been there. I've been in the Department of Justice or against justice. I've been there. I've been a prosecutor and I've been a magistrate. So I've been there. I know how the hierarchy works. The suggestion would be that the first of line would be to file your complaint with the court manager and give them 5 days to respond. If they do not respond in 5 days, which they never do, you escalate the matter to the area court manager and copy in the court manager as well. Because now the superior one at top would know that the one down below is not doing a job. And then you go on, and then you copy in the regional head. If a matter is serious enough, copy in the whole grocery list of people. Go for it. Go for it, so that they all know what's going on. So if you need to understand where does your rights fit in, because there's a load of rights that's at play here. I calculated that there's about 800 rights that you could have in terms of the Maintenance Act, in terms of the regulations, in terms of the DOJ Code. So there's a lot of rights, and I am only highlighting certain aspects thereof. And I've divided it into 4 sections. The first one would be the application phase. That is outside of court. So it's not inside court. So you would have a hierarchy of complaints procedure, the application phase, and we'll discuss this in a little bit more detail in a while. So it's the application phase, it's the investigation phase. The application phase is where you get the documents ready and you proceed to lodge your complaint at court before it's even heard. So that's the application process. After that is the investigation process, where the maintenance officer gives direction to the maintenance investigator to attend to that. And they've got certain duties that they need to fulfill in terms of the DOJ Code. And then you would have your informal Section 6 inquiry. Very important there is the role of the maintenance officer, because it's usually here where the problem starts. The problem usually starts escalating from bad to worse to detrimental in the Section 6 process. It's usually in the Section 6 phase where you also have the legal advisors of the opposing party present, and you are being subjected to bullying by legal representative. And I'll talk about that in a while. And then we change from the Section 6 inquiry to the more formal Section 10 inquiry, which is done in court. Remember now, your complaints procedure of things happening in court is different than the hierarchy of complaints which I just explained. Court manager, area court manager, regional, whole grocery list of people. In terms of the formal Section 10 inquiries, which is done in court, that is an appeal or a review procedure, which we'll get to in a moment. Now I want to talk about the DOJ Code, codified instructions, code, family courts, maintenance. We just call it the DOJ Code 26. And a while ago, some of my colleagues started to distribute this amongst the public. And we were also made aware of that by some of the personnel of the NPA that gave us the information. And I read through it very meticulously. And because I also felt that, you know what, it might not be a good idea, because giving this out to people might not be the best interest. Because you would get this, you would have this to your disposal, and once you go to court, if you quote this, then you're going to have loads of resistance, and you might be victimized. So I read through the DOJ Code, and I'm going to refer to certain sections thereof. Section 3.1 says that this code is available or applicable to all the officers of the department, which includes maintenance. 4.1, very important, that non-compliance of the DOJ Code could amount to punitive actions being taken. Very important. Here it says, black and white. The DOJ Code is a prescriptive guideline issued to all the personnel of the Department of Justice, and it's like their Bible. They have to abide by that. Those are the rules that they need to play with or within. Section 6.1 thereof says that a hard copy must be in the library at the courts, and the maintenance officer and the maintenance clerk should also have a copy thereof. You know that 90% of the courts that I've attended to, and I asked them, do you have a copy of the DOJ Code? I just want to make sure of something. They don't even know what it is. But they were appointed by the DOJ. They signed that, they read it. So we can keep them to it. And then very important, Section 6.1, where it says that, you know what, the DOJ Code does not contain any confidential instructions and is accessible to everybody who might have an interest in that. Wonderful words. We can distribute it. We can splash it all over, because this is not a private document. If you have an interest in a maintenance case, then you can use the provisions of the DOJ Code. As clear as that. Please bear in mind that the DOJ Code is just a prescriptive guideline. It is not the law. So you cannot stand in court and quote the DOJ Code. You cannot, because the magistrate would look at you and think you are from Mars or from wherever, because he's never heard of it, because he's not bound by it. It is not a ruling, it's not case law. It's not enacted in any way. But for you to exercise your right, you can use this. This would be your tool that you could use to lodge a complaint or to draft a complaint. So let's just quickly run through a couple of the rights that I identified as quite important. First of all, the court hours are irregular. We've had a case now of matter in Simonstown, I think, where there was a poster on the door where it says maintenance will only be done, or maintenance inquiries will only be done from 8 or from 9 to 1 every day and not on Fridays. What utter bull. It's not true. It's not happening. But yet we see that each and every day. Section 34 of the Constitution says that you have a right to access to courts. That's your constitutional right. Why are they taking that away from you? You can use this in your complaint. Section 3 of the Magistrate for the Maintenance Act says that every magistrate court shall, within its area of jurisdiction, be a maintenance court. So why should the maintenance section be singled out? Why? Because it's also considered to be a court in terms of Section 3. If you have these type of complaints, you can escalate that in terms of the hierarchy process, which I explained, area manager, court manager, area manager, regional, and then escalate it. And if that happens, you can copy in Advocate Reuters as well, because he'll kick some serious ass. Because that is totally wrong. That is an infringement of a basic right. Absolutely. If there's no personnel in the maintenance office to assist, we get that often. They pitch up, they stay there for 10, 15 minutes, and once you stand in the office, you just wait. And it's a hurry up and wait game. Not on. They are employed, like most of us are, and they get a salary to do a job. They have to be there. If you are in a process where you have to sit for the whole day and you are not being attended to because there's no personnel available, they are somewhere in the building, probably on Facebook or wherever, WhatsApp to their friends, but not in the office doing their job, then insist on a Section 11 and Regulation 5 subsistence and allowance voucher, because you can. You're very much entitled to that. Rude personnel, we get that all over. It's a balancing act, people. I've seen maintenance officers sitting in a small little office being exercised to one portion of the court, probably a prefab building, getting very hot in summer and very cold in winter, because no one wants to deal with maintenance. It's like your gay stepchild in jail. Nobody wants to talk about that. Nobody likes that. They don't want to talk about that. They don't like it. So I see the personnel, and I work with them quite a lot, and I see the frustrations that they have. It should be discouraging if you go to your work, wherever you might work, even if it's an attorney, and you come to your office and you look out the door and there's 40 people waiting for you. Would that be discouraging? Yes. Remember now, the whole maintenance arena is an emotionally loaded arena. So once you have the people in, you get the husband and you get the wife together, there will be sparks. But it's up to the maintenance officer to keep control. And you know what? It's not always possible. They are also just human. They have a family as well. So it's a balancing act of, you know what, having some form of sympathy with them, but also to make sure that they do their job. What happens is, and this is all that we saw quite often, is that you ask to complete the form and just hand it in court. Fill in the J101 form and then you just hand it in court. No, absolutely not. You can complain about that. In terms of the DOJ Code 15.2, says that the clerk of the court must assist you to complete the form. That is your right. you can insist that they assist you to complete the form. It is not the task of the security at the court to fulfill the obligations and the duties of the maintenance officer or the maintenance clerk. Not at all. You know what? It is your right to complain about that. Escalate the matter. We see that very, very, very often. Once you submit your forms to court, most people are turned away on the first instance because they simply do not have the right documentation. It's not been explained to them. They don't know what to expect. They just know that they want to file for maintenance, they need to go to court, and this is the documents that they think the court would need. And then the clerk of the court turns them away and says, but you know what, your case will not be heard. It's not ready yet. Yes, sure, there is a responsibility in you as the complainant to ensure that all your documents are ready, because no one else is going to do that. So you have to do it on yourself, or by yourself. There's some form of responsibility upon you to gather your own evidence. But the clerk of the maintenance court should make no decision on the demerits or merits of the case. So the maintenance clerk cannot turn you away and say, but you know what, up until now, even though you do not have all the documentation, they cannot send you away and say, you know what, you don't have a case. Come back when you get everything right. If you file a complaint, use this specific section of the DOJ Code 15.3 in your complaint, stating that you were turned away by the maintenance clerk and she made a decision on the merits or the demerits of the case. That would be your defense. Turned away because they don't have ID documents. Very, very, very specific section 15.1, where it says that no applicant would be turned away because they do not have an ID with them. Enforce this, enforce this. This is your right. You can complain. The file went missing. Oh, my word, how many times have we heard that? I don't think it's the Department of Justice, it's the Department of Search, because they're forever looking for files. If I go to court and I ask the maintenance clerk, you know what, won't you just please draw me this file? I say a silent prayer with loads of expectation that that would miraculously appear. And about 90% of the times, they say they can't find the file. It's not my problem. It's not my problem. It's their filing system. In terms of section 31, the clerk of the maintenance court must keep a record of the movement of the file. So if she takes the file to read in the loo, there needs to be a note on the file, who took the file, when, where, when will it be returned. There should be a register of movement of files. So there should be no reason whatsoever, none, why a file goes missing. I reiterate that there should be no reason whatsoever. They've got all the systems in place. No file should go missing. I explained the security that takes over the roles. Now we come to the investigation phase. We spoke about the application phase, now we come to the investigation phase. The duties of the maintenance officer. What happens quite often is that all the documents are submitted to court or to the maintenance officer, and you expect a date at a later stage. Okay. And then you expect a date at a later stage. It is up to the maintenance officer that must establish if there is sufficient information contained in the file to actually proceed with the matter. It also speaks about the delays in the matters governed by section 17.1 and 17.5. Those are all contained in your handout. I suggest what you do is, instead of going through each and every one of them, that you go through them. It is very, very, very detailed. And those are the things that you could use in your complaint. Record keeping. Yes, there should be record keeping of each and every note, every evidence, every form, every document that was submitted in the application needs to be filed. It's in terms of section 22(4) of the DOJ Code. This is just all that I've already spoken about, the investigation phase, handed in court, but not in court file. That speaks to record keeping as well. I'm not going into much detail with regards to that. That's all. Respondent not giving all details to the maintenance officer or the court. This happens quite often. You go to court, you know what? You need to prove to court and say, I want maintenance. I have a case made out, I want maintenance. And then there's reliance upon you to submit evidence from the father's side to say, but you know what? He does have a car. He does have a house. But sometimes you don't know that. You don't know. You are not privy to his bank accounts. There is a procedure in the Act, and we dealt with that previously in previous dialogues. There is a procedure where those banks could be subpoenaed. Everybody that has an interest or can shed some light on the financial affairs of the father could be subpoenaed to court. Why is it not being used? Why? The Section 6 inquiry, yes. In terms of the Constitution, Section 32, you are well within your rights to ask for the details of your file. Some maintenance officers keep the details of that file better than a state secret. No one's allowed to access that file, which is absolute rubbish. In terms of Section 32 of the Constitution, you are allowed to have access to that. It is not a guessing game. It is a civil procedure, or akin to a civil procedure, where it is full disclosure of all parties' financial affairs, which means your affairs, as well as the father's affairs, needs to be disclosed, and you have the right to have access thereto. Again, we talk about the files that's going missing. Recently, we also saw that some of the orders that I saw were signed by a maintenance officer. That's totally wrong. That is not considered to be a valid court order because it needs to be signed by a magistrate in terms of Section 32(3) of the DOJ Code. Where there's not a maintenance officer available, we see that also. Maintenance officer is not available, or the court do not have an appointed maintenance officer. If the maintenance officer is not there, then you know what? Ask to speak to the public prosecutor. Because the public prosecutor, in terms of Section 4(1), is deemed to be a maintenance officer. So you're allowed to do that. That's one of your rights. I'm not going into detail with this. This is just about the arguments that a respondent might have other children, so he cannot afford that. Section 15(4) of the Maintenance Act clearly says that one child does not take preference over another. These are all in the handouts, and I would suggest that you read through this and you use that for your complaints procedure. Then we come to the formal, we're nearly finished, the formal Section 10 phase, the failure to appear by the respondent after being served properly. If the matter was set down, it was properly served in terms of the DOJ Code 26, and it was properly served, the maintenance officer in terms of Section 20, or portion 26(3) of the DOJ Code must ensure that the method of the service was written on the documents, on the file. So they should say, you know what, it was done by WhatsApp, it was done by fax, it was done by the sheriff, it was done by the police. So there should be a note. So you would know where's your file right through the whole process. Just to get back to that one, if a respondent fails to appear on this date that was set down for the inquiry, and it was duly served, there was enough evidence that it was duly served, then the maintenance officer must apply for an order by default. I see in practice what they do is they just issue a warrant of arrest, or they just give you another date, which is wrong. You can, in terms of section 26(1), you can insist that a default order be made. Returns of service is a long list of rights that you have, and I would suggest that you read through that. That's contained in section 31(1) to 31(8) of the DOJ Code. I'm not going through that. Now we get to the formal phase, the section 10 inquiry, which is in court. Remember now, like I said, if it's in court, then your only recourse there would be a review or an appeal. Section 18(1) of the Maintenance Act says that if in a maintenance matter, any person is unsatisfied, then he could appeal the matter. That's section 25, sorry. Then the matter could be taken on appeal. Transfer of files we also have a problem with. There's certain provisions in the DOJ Code that you would need to be notified, and the procedure that needs to be followed once you transfer a file from one jurisdiction to the other. Please read this, because we see that quite often, and people are still frustrated because they don't know. Files take 6-8 months. A dove takes 4 days, but why should the postal service take 9 months? I mean, it's ridiculous. This is the portion then that you could use in your complaint. Legal representation. Yes, we spoke about that. If you feel that you are being bullied in court by a legal practitioner, attorney like myself, I don't get any complaints, but yes, the matter needs to be escalated to the LPC, the Legal Practice Council. You are well within your rights to lodge a formal complaint, because they also have an ethical duty to act professionally and responsibly and in the best interest of the child, even though they represent the respondent. So your recourse there would be to lodge a formal complaint at the LPC. Bullied by the legal practitioner, as I said, report the matter to the LPC. I can also just refer you to the case of Anna Mutimunye. Oma Anna Mutimunye. And that's a nice, that is something that you need to put in all your complaints. In this case, this poor Oma, it was somewhere in Mpumalanga. Bjorn knows the case off by heart. I think he's on speaking terms with Oma Anna Mutimunye. But there was a comedy of errors that happened in court. A total comedy of errors. And the maintenance officer, the maintenance investigator did not do their work. And Oma Anna Mutimunye approached the courts, and she sued the Department of Justice and Constitutional Development, as well as the maintenance clerk and the maintenance officer in their personal capacity. And she won the case. She won the case. At this stage, it's an unreported case, and it was by Judge Hinstra. A very good case to have. It is available on the website www.childmaintenance.org.za. In the top right-hand corner, you'll see a portion called public. There's a public library where this case is available. Appeals are done in terms of section 25 of the Maintenance Act, where it says that, you know, if you take the matter of appeal, the High Court can make any order that it deems fit. But very importantly, the court will not, or it does not mean if you lodge an appeal against a maintenance order for whatever reason, it will not suspend the payment of maintenance pending the finalization of the maintenance order. Orders that are not appealable. This is also very important to note. Orders that are not appealable. So you cannot appeal to this even though it was handed down by a magistrate. Orders by consent. So if you consented to a certain order, you cannot appeal to that. That's just counterproductive. Why would you consent then and not appeal to it? Orders to pay for DNA tests in terms of section 21, and then certain default orders in terms of section 18(2). Those are all orders that you cannot appeal. Orders that are indeed appealable, those are any order that deals with the discharge, the setting aside, substitution, variation, increase, decrease, all those that were granted, those are appealable. I'm not going into the complete detailed process of the appeal. I'll leave that to Advocate Mohammed to explain a little bit more how that works. He deals with that each and every day. But yeah, say for mentioning Regulation 50, where of the regulations of the enacted in terms of the Maintenance Act, where it says that the appeal should be noted within 20 days of the order, and if you have a cross appeal within 7 days after that. But that's technical details. Appeals and reviews are quite technical, and Advocate Mohammed will probably touch on that, and as well as Advocate Reiters. This is just the graphic on appeals, which I will not discuss now because we're running a little bit short of time, but it is in the handout and it is available for that. Thank you, guys.
Thank you, Eugene. I hope that you've learned how you can do your rights and your recourses whenever you are struggling at a maintenance court with any of the maintenance staff. So if you want to, all of it is in the handout. I saw some of the online people couldn't get access to the handout. We will make it available, and it will be on the www.childmaintenance.org.za library, where you'll be able to download it whenever you would like to read through it or have access to any of the other files. In the library, we've also got the DOJ maintenance forms, as well as examples of affidavits and examples of court orders and how these court orders will be done in the courts. In a case where you would like to see how you can do some of the complaints, we've got different examples of how you can complain to the court manager, area court manager, as well as to the regional lead of the Department of Justice, in case you want to complain to any of them. Earlier this year, we had Advocate Waleed Adams of the Public Protector's Office at our sessions. And in case any of you would like to get his details, please ask us, or we will make it available. Waleed Adams is the public protector in the Western Cape, dealing with these type of complaints from the maintenance courts in the Western Cape. So if any of you need his details, please just ask us and we will make that available. Thank you very much, Eugene Opperman. I'm glad I'm a friend of yours and not on the other side, because I don't want that shit with the sugar coating on it that looks like chocolate. I don't want to deal with that. So I'm glad I've got Eugene Opperman on my side. Next, I would like to introduce Nicole Lawrence. She is an attorney, and she's the briefing attorney for Advocate Mohammed, and she will give us a little bit of detail as far as how the case came about and then how she briefed Advocate Mohammed. So I will hand over to Nicole Lawrence.
Good morning, everyone. I'm Nicole from Nicole Lawrence Incorporated. To give you a very brief background, I'm going to leave the detail to Advocate Abdurauf regarding the appeal PN vs. TM 2019. So basically, the initial application for maintenance was launched in December 2016, and it only went to trial in the Magistrates Court in September 2017. So, as you know, the maintenance court is many postponements. It takes a long time sometimes to get to trial if you don't have someone pushing forward to get it and let the maintenance officers do their work and get the files in order. So in this case, both parties were employed. The mother experienced some health issues, and she needed assistance from the father, who was the respondent. If you read the judgment, she was more or less and had a monthly shortfall of just under 10,000 rand for the minor child. Initially, the father tendered 500 rand for the child per month, and this was made an interim order in the magistrate's court. And during the informal inquiry before the maintenance officer, The father did not disclose his financial position. And despite this, the maintenance officer still recommended R1,000 per month for the minor child, and which is completely ridiculous in the circumstances because he didn't have enough information to even make that recommendation. The matter then ultimately did go to trial before the formal inquiry before the magistrate, and yet the father still did not disclose his financial position. The magistrate did ask for specific documents to ascertain his financial position. Still, he did not give that to the court. Then the matter, despite this, there's no information, very little about the father's financial position. The magistrate still proceeded with the trial. It did come out from trial that he had a provident fund. The value was over R1 million. However, there was not enough evidence of his financial position for the trial to actually proceed to determine what his financial position is compared to the mother. Well, essentially, the court did not satisfy itself as to the financial position of the father, and it did not come to a fair and equitable maintenance order, as it lacked evidence to compare the financial positions of each party to make an actual fair order for the child and in the best interest of the child. So essentially, after that, we were instructed to handle the appeals proceedings. And at the time of the appeal, the father still made no payments in terms of the interim order that he tendered, and also never made any payment of the 1,000 rand ordered by the magistrate. So, yeah, that does happen often. So ultimately, in a nutshell, I'm not going to go too much into the appeal proceedings and arguments made. Advocate Abdurrauf will go into the law and the arguments made and the views of the appeal court. But in a nutshell, the argument before the appeal court, which was the High Court, was that the magistrate didn't make a fair and equitable order as to the, as it did not have enough, it did not conduct a thorough inquiry. So obviously, as Mr. Opperman said, there's obligations for a maintenance officer to do his job, and in this case, he couldn't make a recommendation because he didn't have enough information. Likewise, the magistrate also has a duty to make an order in the best interest of the child, having regard to the financial positions of both parties. In this case, that didn't happen. The financial position of the father was non-existent. It wasn't before the court, essentially. In a nutshell, the magistrate court, the appeal court, was of the view that the magistrate's court did not make a fair and equitable order and did not conduct a thorough inquiry. And essentially, the overarching principle of all children's matters, it did not uphold the best interests of the child in this case. Ultimately, the appeal court ordered that the father's provident fund will be used to pay the future maintenance of the child, as well as the arrear maintenance. They ordered 100,000 rand from his provident fund to settle the arrear maintenance. I'm going to leave it there. I'm not going to go into the nitty-gritty of the appeal and the legal arguments made. I think Advocate Abdurrauf will do that. Thank you.
Right, guys, according to the schedule, we were supposed to have a quick break, but I think we are moving so enthusiastically forward that we can ask Advocate Mohammed to actually start off with his presentation. He's going to wow us with some insight.
I'll take this one.
Okay.
Maybe get closer laptop. I'll put my laptop on your laptop. And, I don't know.
Yes, let's do that.
And then I'll put this in here.
Can I get a copy of
No, I'll get you what the.
Yeah, because I'm going to stream it there as well. Sorry.
No, please. I can see that good diary.
Just close down your phone.
So I'll make it here.
perfect.
Good morning, everyone. Thank you for having me here today. It's very exciting. I'm with the big boys today, so I'll have to try my best to put up some type of a show. I had Mr. Opperman speak first. It's sometimes very difficult to emulate what your predecessor done, so I'll try my best. So today we're discussing appeals, okay? So my approach will be strictly strategic. I would like you to, at the end of this presentation of 45 minutes, know exactly how to attack a maintenance matter, how to deal with it, and how to ultimately take on an appeal, and how to deal with an appeal. It's very important because I do not believe any court case comes to an end at the initial order. That's nonsense. No, there's always an option of an appeal. The sad part is, obviously, we stop there. So I lost, done. No, you should appeal, because it does not mean that the magistrate or the judge who heard the matter and made a decision is right. He's human. He could have made a mistake, not applied his or her mind properly. So we should always make use of the appeal process. It's very important. And you'll see in this judgment how the appeal process assisted the mother from not only obtaining a maintenance of 500% more, what the court initially granted, but also attached money elsewhere and gave the money to her. So had she not have appealed, she would not have received that. Okay. So I'll give you some background on strategy first. It's very important for us to know how to deal with maintenance matters first. And if you're on the same page, we'll of course see how I deal with my matters and how I dealt with this matter. Okay, first things first. I typed this out while we were sitting here because Eugene had notes, I didn't have notes. So I thought, get something here. Okay. First thing first, know exactly what you want. It's very important. Attorneys, advocates, many of them don't know what they want. The client comes to them. They believe knowing what you want is going to the maintenance court, asking for the maintenance. That's not knowing what you want. Knowing what you want means getting what you want as well. So you need to know exactly, what do I want for my case? I want a deduction. As a father, for example, I want to pay less maintenance. Okay, that's fine. The mother, I want to get 2,000 in maintenance, 5,000, 20,000 in maintenance. I know exactly what I want. Don't leave it for the lawyers. Lawyers don't think on your behalf. Lawyers don't think. They should think, but they don't think. You're the one, as the applicant, who is supposed to be the one to know exactly what you want. If a client comes to my office, the first thing I ask the client, ma'am, what do you want? Sir, what do you want? Tell me what you want. I want custody. I want primary care. I want to relocate. I want 10,000 maintenance. Then we know where we're going to. I have a magic ball here. I have powers, for example. I tell them that. Tell me what you want. Don't say, advocate, you tell me what I want. It doesn't work that way. Okay. Have a plan how to get there. Very important. In all my matters, Nicole's matters as well, when me and Nicole sit down, we sit down for 20-minute strategy. We're not here to discuss, yes, what is a plan of action here? How are we going to break this case up? How, there's counsel on the other side, there's a magistrate on the bench, there's a judge there, that doesn't bother us. Do we have a plan of action over here? Their strategy is that, our strategy is this. If we don't have a strategy, we'll lose. That's how it is. Okay, have a plan how to get there. Then you should spend all your energy on execution and stay focused. In a maintenance matter, simple matter, Eugene mentioned it as well. A client comes to my office over here. I have 10 different things I must do before the time. First things first. Do I have the financial circumstance of my client first? I'm not bothered by the father or the mother on the other side. I'm not bothered by that. Has my client disclosed to me exactly what her financial position is? What does a child cost? And that's my foundation in maintenance matter. If the child costs 50 Rand, simple figures here, it's impossible for the father to pay 100 Rand. It doesn't make sense. If the child costs 50 Rand and the mother says the child costs 50 Rand for the last 2 years and her salary is 40 Rand, mother, you're lying to me. We're not giving you a proper job here. It's impossible. But if the child costs 50 Rand, the mother says the child costs 50 Rand, in my first instruction, in my first meeting, and her income is 80 Rand and the father gets 20 Rand, then we can maybe look into it. Let's deal with the matter. Okay, so first things first, in a maintenance matter, my primary objective is to determine what does the child cost. Full stop. And if I determine what the child costs, from there I work further. So if the child costs 100 Rand, the father earns 200, the mother earns 300 Rand. The proportion is to work out. But how do I determine what my maintenance claim should be if I do not even know what the child costs. That's what I'm saying. You go to court with your lawyer, you're sitting there, you fill in a nice maintenance application form. The claim is 10,000 Rand. The parents together earn 7,000 per month. It doesn't work that way. So anyway, I don't have time for that. I most probably would have done that if I started off the first month of doing maintenance, but I'm no longer. Because Hassan will tell you as well. I mean, I've been dealing with him for many years, 15 years ago, like Mr. Hassan. And I gave him a hard time, but that's how we deal with these matters. Going further, you spend all your energy on execution, stay focused. Stay focused, very important, stay focused. Know what you want. How do you stay focused in a maintenance court matter? There are so many tools. Mr. Opperman will tell you, number one is, first thing I do is, do we have a bank statement on the other side? Very important. Back in the day when I used to do a lot of maintenance matters, I moved a bit more to relocation, child custody matters as well, but I still do maintenance matters. I used to have connections at ABSA banks, standard banks, all different banks. We used to subpoena. I used to draft those subpoenas myself, get the maintenance officer to stamp it, take it to ABSA bank, I had a connection there, and that person 2 weeks later gave me the full banking details. The reason why I make use of bank statements. Because that gentleman will come to me, or into the maintenance court and say, I earn so much money, and I only have so much left to maintain for the child. Fair, I believe. I mean, if a client comes to me and she's excessive, I'll tell her she's excessive. But how can you say he only has 500 Rand to pay maintenance if his alcohol bill is 2,000 Rand for the month? His entertainment, roses, chocolates for the girl thing is so much money, hotels. It's exciting. I actually do not charge clients to go to bank statements. I find it entertaining. So I stop the bill and I go to the bank statement. First, entertain me wise, Mark. Then later on, I bill if but I find it entertaining, finding people's lives. Because from a bank statement, a credit card statement, that's why I pay cash for everything. So, you can find the whole person's life. You'll know where the person was in the morning, the afternoon, or the evening. Simple. People tap all the time. Bank statements, very important. Get the bank statements, subpoena them. The banks are very useful. Banks don't charge. They subpoena them. ITC checks. Very important. The father comes to you and he tells you, or the mother comes and tells you, I cannot afford to pay maintenance or whatever amount. Remember, I have a base. I know child costs 1,000 per month. That's my base. Done. I'm working towards the 1,000 Rand. If my client must pay 900 Rand towards that 1,000, my client, the mother, she must pay. But if the father must pay 100 Rand, he better pay that 100 Rand. You know what? It's fair. Fairness here. If he earns much less than the mother, he must pay less. ITC checks, very important because either check the credit check. The father says, I do not earn any money, blah, blah. But he applied for BMW, and in his BMW application, he says, I earn 20,000, 30,000, 40,000 per month. How does it work? Doesn't make sense. IT checks are very important. Do it. Maintenance officers, they should do that. Maintenance investigators, they can do that. So you do your homework, you get your stuff in order before you even go to court. Then, social media. Love it. I enjoy Facebook, Felicity. We met on Facebook, WhatsApp, and all those things. Instagram. Make use of those tools. Check the person's lifestyle out. I don't charge for that as well. Nicole will tell you. Give me the person. I'll first take an hour there checking out his media, where they go to. Okay, that looks familiar. Find out to know the person's lifestyle, where the person stands. Do your homework. Free. This is free. But who should actually do it? Not me. The client should do it. So I brief the client at first meeting. I make him excited or she excited. I make her feel she owns this case. It's her case. Because in the court case, in a maintenance court matter, what's the case's name? It's in Felicity versus Mohammed. It's not Eugene Opperman or that attorney. So Felicity owns that case just as much as I own that case. Therefore, I can control that case. It's my case. It's not your case. It's not the maintenance officer's case. It's my case. So I will fight for that, okay? Then spend all energy. That's very important. Then, for example, the person will say, whatever, from the social media, no, I don't have time. But he's bragging this restaurant, that restaurant. So you're building a whole investigation on this person before you even start working. So I have a presumption of what type of person I'm dealing with. Okay. Very important, number 4. And this is the most important one. Don't expect anyone to be on your side. Moms, come to my office, you can cry. The cow will tell you, I have tissues over there. Felicity, so I have tissues in my office. I stand up, I get the tissues. I first take the first one off because I dusted. And here, once you're done, ma'am, just continue. I'm not on your side. I'm here to find out mathematics. Maintenance mathematics is a mathematical equation. It's simple. It's simple mathematics. I teach, after my clients are done with the maintenance matter, they are experts in Excel. Because Excel, they hadn't so much fun. They can work out the calculations and everything. And the funny thing is, when they come back to my office, they say, this advocate is cold. But when they come to my office a second time, oh my gosh, you must see the research they come to my office with. All the stuff they've done, they got this, they got that, they got that. Okay, so that's fine. Nobody's on your side. And the same way if I'm in court, nobody's on my side. I do my own thing. It's your case, so fight for your rights. Don't hold back. Very important. You need to fight. As an attorney, as an advocate, as a client, as whoever you are, you need to fight. I'm not talking here on behalf of the DOJ. I'm not talking here on behalf of anybody else. I'm talking on behalf of the individual. So getting a different perspective. Okay. Now the question I have, where does hope come in? Hope. You know, many people come to maintenance court first, and they hope the maintenance magistrate will find in their favor. They hope they will get assistance. Okay, that's a part of the equation, because when they came to my office, I hope advocate up the road will get me what I want. They hope. So where does hope come in? The only thing you hope for is that your matter gets heard. That's the only thing. No matter how good I am, hope won't help. That's the only thing I hope for. Right, Mr. Opperman? That's all that you can hope for. Then go further. Everything else, your strategy, so yours must be strategies, and plan towards. You strategize and plan towards, sorry about that. That's everything else was that way. You need to have a plan. If I pick up the pen with a file, why am I picking up the pen? Why am I reading over the file? What is my plan of action? Where am I going to? What's the narration? When people contact me and ask me, advocate, please, can I email you something before the time? I ask them straight, why are you emailing to me? What's your spelling? What's your grammar? Will I speak this? Why am I reading that? I'm a busy person. I'll read through it if I have to read through it with a purpose, but why am I reading through it? What's my strategy? What is my plan? If my plan is to look for spelling, great, I love doing that. If my plan is to look for this document to determine whether or not the other party can afford to pay, that's my plan. I need to have a mindset. But I cannot have that mindset unless we have sorted out this first 5 points. It's very important. Okay. So that's it. That's on that specific point. Let's go to the next document. So what I done was, I think to get a very good illustration on this appeal case, Nicole was very instrumental in this specific case, and I know the reason why she took on this case. We don't usually take on appeals in other provinces. If we have to, but she could see the injustice that happened in this specific case, and therefore you do those matters. It's not always nice to go to the Buntus there in Grahamstown High Court, and that's a weird court there. I'm not putting down Cape Town at all, but if you compare me, Wynberg is a nice area. I like going to Wynberg. So when I pulled up in Grahamstown, potholes everywhere. I pulled up by the court. Number one, there's no parking meters. You can park anywhere, and then it's gravel. So I really thought maybe the court is somewhere there. No, the High Court is just here. Not insulting anyone. I'm just saying we're lucky to be in Cape Town with lovely courts. And I still got a fine on my way back. So the way to demonstrate this case, and please bear with me here, heads of arguments. So this will obviously assist everybody. My angle of attack. Remember, I'm not drafting heads of arguments here for the sake of drafting heads of arguments because I can build a client and I can build a magistrate. I'm drafting heads of arguments for the purpose of winning this case. There's a difference between the two. The difference between having a lawyer representing you and billing you the whatever fee charges and going through the motions and say our clients want 1,000 maintenance, the father's not paying, or a lawyer going to court and knowing when I leave this inquiry, I will get my 1,000 maintenance. It's the difference between like signing up for weight loss and actually losing weight. It's the difference. Okay. Sensitive topic. Okay. So this are the heads of arguments. I just copied and pasted from my files. It's what I emailed to the magistrate from Cape Town. So introduction, this appeal is in relation to a child maintenance award made by the Magistrates Court in PE. Okay, there's some background information. The judgment is over there. So I give some further information, the amount which Nicole dealt with, the mother, the father, the respondent, and the applicant, that's fine. The child's name, which I can't keep too long on the screen. It's okay. So this matter is appealable. This is provided for in Section 25(1) of the Maintenance Act. So the footnote says the following: any person aggrieved by an order made by the Maintenance Court under the Act may, within such period and in such manner as may be described, appeal against such order to the High Court having jurisdiction. So that's how the appeal works. So when you draft heads of appeal, heads of argument, you need to explain to the court. The judge wants to know on what basis are you appealing. So, for example, if there's had to be a consent to maintenance order, Mr. Opperman will tell me, I can't appeal. So I need to explain why I can appeal this one. I can appeal because I'm not happy with that. Okay, the mother acted in person when she filed the notice of appeal. So that's what she done. So you have to file a notice of appeal first. And then later on, the magistrate will give his written proof of judgments. Okay. So the mother's case, as espoused in the notice of appeal, can be as follows. So this is the mother explained. The maintenance investigator should have been instructed to investigate the matter, number one. There was no maintenance investigator. Yes, another part of my arsenal. I'm very disappointed that the fact that there are no maintenance investigators firstly appointed, and secondly, doing their job in the maintenance matter. I remember in the early 2000s, where maintenance investigators used to investigate matters. I used to request an investigation. 2 weeks later, I get an ITC check, a credit check from the maintenance investigator, and I used to get bank statements from other parties. Just standard procedure. Now, they're ill or they're not appointed. That's a constitutional problem, violation. There needs to be a maintenance officer. It's not an investigator appointed in maintenance. That is constitutional. And I remember back in the day when I used to do maintenance matters, the maintenance officer, him or herself, were not, trained to be maintenance officers. That's obviously challenging. Okay, so she argues the magistrate erred in his finding that ignored and or incorrectly considered the evidence provided. Okay, in other words, the facts that were provided by the witnesses are presented differently by the magistrate in the judgment. So, for example, she might have said she earns 1,000 and the magistrate said she earns 5,000. Okay, and that's what I say over here. Therefore, the magistrate erred in the judgment in finding that the sum of 1,000 rand is fair, reasonable award, and the child's best interest. Okay, so this is the boring parts, guys. We're still getting to the exciting parts. Okay, the basis on which the honourable court may deal with the matter is determined whether a maintenance award made by a maintenance magistrate consider the following. Okay, so this is my angle of attack. Remember, I need an angle of attack. I needed to. Remember, judges are lazy, magistrates are lazy. Do not for one single minute think they will think on your behalf. And I've changed my attitude for the last 10 odd years, knowing that I need to think on magistrates' behalf or maintenance officers because they're busy also. So if you don't bring your angle to them, where you're coming from, how do you expect them to spell it and to see it? I don't know. Maybe you have powers, I don't have the powers. So the question I have posed here is, did a proper investigation into the financial affairs of the parties take place prior to the formal hearing before the magistrate as provided for in the Maintenance Act? That's a question I posed. This responsibility falls on the maintenance officer and the maintenance investigator if so instructed. That's on the angle of attack. If the magistrate says that there was not a proper inquiry, my appeal stands. That's just logical speaking. I can't say he made a mistake. That's right, he did make a mistake, but that's not the angle of attack. Has the court properly considered the following determine the maintenance award? The means and needs of the mother, the means and needs of the father, the needs of the minor child. Furthermore, it must be decided whether the magistrate conducted a proper inquiry as provided from the Act. Very important, and the Children's Act and our Constitution. So you go one step further. It's not only the Children's Act and the Maintenance Act, but the Constitution as well. If there has not been compliance with the maintenance officer by the maintenance officer or magistrate, then the matter should be referred back to the maintenance officer for proper investigation. So my angle over here was clear. The court didn't grant me that relief. My request here was that the matter should go back to the maintenance officer and the maintenance magistrate. However, the court said no, and I saw the judgment, part of the judgment. Later we'll see. No, this matter has been extradited. It's upped by 500%. Okay. So material facts, very important, clearly over here. And the civil court made a mistake. And I read that judgment, of course, the evidence very well, the transcript very well. The complaint was against the father, and she wanted 5,000 per month. Okay. Then she increased it, I think, to, then he offered an interim arrangement by 500 per month. This 500, small amount, Nicole said that early on. The maintenance magistrate inquiry before the magistrate took place on that specific date, okay? The parties represented themselves, that's fine. And the form required the mother sought an order for 5,500. She approached the maintenance court after, now because of her health, consequently, she had to reduce her workload, okay? But the facts is important. But duly required, the mother testified that the personal expenses amounted to 32,000 rand per month, and that of the child was 20,000 per month. They should provide evidence. A few items were challenged in relation to the child, but nothing was really conceded to. The mother further provided a schedule of the property she owned. So she owned quite a lot of properties, right? But if you look at the value and the equity is not much, it's 41,000 rand. So she earned properties worth 9 million. And that's where the magistrate made a mistake. He quickly rushed through the stuff. And he saw, okay, 9 million rand properties. People bond properties nowadays. I mean, who owns the property? You know, that's not something to about. But he saw the 9 million rand and never used his brain and looked at the value of the property. He didn't use his brain. The mother further provided bank statements from personal accounts. Okay. The mother was questioned about the maintenance officer, XYZ. Okay. The father testified the chief. He offered an amount of 250 rand per month. That's a very paltry amount. But I have no problem with someone offering 1 rand if you can only afford 1 rand. I don't believe. I believe in fairness. If you're unemployed, apply for a job and come back to the maintenance code every 4 months to show that. If you can only afford 100 rand, you can only afford 100 rand. But I consider that based upon all other factors as well. If it's fair for 100 rand, if the mother is a multimillionaire and she owns many properties and she's wealthy and the father owns 500 rand per month, 50 rand maintenance can be reasonable. Okay, he holds a law degree. I'm not saying that is that of any value? No, it doesn't help much. It doesn't mean much. Okay, he lives in Zama Butterworth. Okay, that's fine. And he has no rental expenditure. So he has no rent, number one. So I can unpack his case. Remember, I can't wait for the magistrate, for the appeal court now to go through this document. Most probably they won't. But they'll look at it quickly. I need to present it to them. He owns immovable property which he rents out. He receives approximately 9,000 per month income. He pays 10,000 to his bond, so basically that cancels out. He receives a monthly payment of 4,000 from his pension fund. His total expenditure is 90,000 rand. He has a CC, that's fine. Okay, this is the most important one. Exhibit D, in 2012, he received 600,000 rand from his provident fund. And the balance of 1.3 million were invested. So he gets a monthly payment. I think we can look up there, or some money comes in. I think 4,000 comes in from there. So here we have an asset. Right, of 1.3 million rand. The mother's net worth is worth 40,000, not much. But they are. By the end of the father's cross-examination by the mother, the magistrate required the following. This is where the crux of the matter comes in. Okay. This is where the appeal stops. The court requested from the maintenance, from the father, a statement from the preservation fund, from pension fund. What's happening with the 1.3 million? His property in Vincent, his rental income, and the agent costs. Okay. Details of the companies he worked for and his bank statements of the company. So the court requested that. So what happens? I request information, I wait for the information to come and then make a decision. And that's logical sense. You don't make a decision before you get information, unless they work differently there. Okay. The maintenance officer argued that amount of 1,000 rand, from 1,000 rand to 1,200 per month, a child maintenance be paid to the father. I fail to see that. If the child costs 20,000 per month, right? That's a factual thing. It's not in dispute. Nobody's disputing that. On the papers, the father alone has an asset worth 1.3 million rand, and he owns a house as well. And he pays a bond on those things. He doesn't pay rent. How can the maintenance officer make an order that he pays 1,000 rand per month? The maintenance officer sorry recommend 1,000. It doesn't make logical sense for me. You know, that's where I'm going. I'm a guy of logic. So he and I has to pay. They recommend 1,000 per month. Child costs 20,000 per month. On the papers, the mother earns far less, is far less worth than the father. But that's fine. That's what they made. That's what she recommended. The father was provided with the date of 11th December 2017 to provide some outstanding information. You know, his net worth, all those things. Okay, that's part of the record. The father did not provide the information, but nonetheless the court nonetheless handed judgment down on 22nd of December. Now, can you see the problem here? Why request information if you're not going to use information? You know? It's very funny. So this case was very easy, one of the easier ones. And the magistrate ordered him to pay 1,000 per month maintenance. Now, where is the justice involved over there? You know, I would have maybe understood if he said, you know what, the information isn't in front of me, too bad, you should have presented it, I am here, you can make a judgment now. But he said, I want this information first, then I'll make a decision. He jumped the gun. Okay, so this is where I came in now. Errors are the facts in the judgment. The magistrate made the following errors. The father did not testify that he used 200,000 rand from his pension. So the father, okay, according to Exhibit D, the sum of that was left. So the court assumed, the court didn't listen to the judgment again, the court didn't take proper notes. The court just assumed that 2 million is gone. The father's current wife does not reside in Vincent. According to the record, she resides in East London. So there could be another mistake over there. But that's not a big problem. Now, this is the court made another mistake. According to the magistrate, the mother testified that she moved to PE and purchased a house with a swimming pool because the father has one. Nowhere the testimonies that mentioned. I mean, I looked through that record quite a few times. So here the magistrate is giving his own stuff in, creating evidence. Okay. And then the next point, the net worth of the immovable property owned by the mother amounts to 9.4 million. He says that this is not what the mother testified. She testified that it was in the region of 41,000. I mean, after you look at the bond amounts and everything. So the magistrate just presumed, he didn't apply his brain. You see where I'm going to, you need to. So let me stop here. The same reason when you do your maintenance applications and you put in your assets, don't let them just presume. You need to put over there, my net worth is so much. So you say, I own a house of 100,000 for argument's sake. But you say bond, 95,000. Therefore, equity, how much, and you put it in it's quite bigly. Equity, how much the value is if I sell it tomorrow, is 50,000. You put, don't let them think. Even if other people think on your behalf, because if you expect them to think, like giving you this and think on my behalf. Some people have the power, I don't have it, maybe you have it, but don't expect it to happen. You need to, think on your behalf. So the way I would have done this differently, if I was maybe representing at this time, I would have put it directly in the magistrate's head that this is my client's financial circumstances, provide another exhibit, write it out, copy it, magistrate, before you adjourn, this is how we confirm how my client's worth is. So he will make a judgment based upon that exhibit, not based upon what I gave him, and he must make his own calculations elsewhere. So for example, if you give him the bank statement and you give the bond document, do you really expect the magistrate to cross-reference? He won't do that. Okay. Then the fun part again is, there's a copy and paste most of the time, but anyway, as a maintenance relates to a child, the best interest of the child of importance, and I mentioned some case law. Furthermore, the golden standard which inquiry should be conducted in a maintenance matter, child's best interest of paramount importance, and I refer to that case in the Tina case, yes, that's the case. The Peterson case, okay. This case I done, this was the case which you referred early on. This is an interesting case as well. In this specific case, the Peterson case was a maintenance matter. I was counsel in this case as well. So what happened here was I represented the client in Simonstown. So when I knew the law a bit, and quite young at the time, and the father said, you cannot afford to pay the maintenance. Well, fine, I respect everybody's right, not everybody can afford the maintenance. And I told the I went to the magistrate and told the magistrate, I would like to subpoena the paternal grandparents. Because, I mean, let's go up the inquiry. That's how the law says, if you cannot go from below, up. And then the magistrate told me, Mr. Abdurrauf, the law does not allow us to claim maintenance from maternal grandparents of children born out of wedlock, but you can go against paternal. Obviously, that doesn't make sense, not fair. It cut both ways. So obviously, we took that to the High Court, and the Western Cape High Court agreed with us. So that was also now and that opened the floodgates for many people to claim maintenance from grandparents. I think the concept of not claiming maintenance from grandparents was non-existent from claiming maintenance, so people knew about that. Then I go further. Equal duty of support, and I've been some cases over there, both parties have this. I like this part over here. Station in life, I use it quite often now. I think it's an old judgment of 1999. But the station in life, yes, many people are different stations in life. At one point, you might be wealthier, you might be not so wealthy. There's some old judgments we refer to over there. It's difficult to find judgments in maintenance court matters. The reason why is it's done in the maintenance court. So unless somebody appeals it, it will be reported. But if it stops at the bottom, it never gets reported. And the duty is not discharged where one spouse earns substantially more than the other. Case law applicable as well. Okay, in determining the amount of child support to be paid, the maintenance court must take into consideration the following. The duty of support is jointly the parents' respective shares of the obligations are portioned between them according to their respective means. Means, very important. What do you mean by means? Salary, money in the bank account, assets, very important. Many people are on the assumption that your means entails your salary, what you get into your pocket. So a person who earns zero but owns a house worth a lot of money can be ordered to pay much more maintenance than a person who earns 50,000 in a month's salary because of the asset. So that's means. Means is not only because I can convert my cash now into an asset. Doesn't mean I must pay no maintenance. Doesn't work that way. So means is as well assets, shares, bonds, stocks, whatever you have. Okay, the duty exists irrespective of whether the child is born in or out of wedlock or from a first or subsequent marriage. Any amount so determined shall be such amount as the maintenance court may consider fair in all circumstances. Okay, very important here. Maintenance investigation prior to the formal inquiry. The maintenance officer provided the Maintenance Act provides a mechanism to ensure that fair amount of maintenance is provided by both parents. Section 7. Now, nobody uses Section 7. Does anybody use Section 7? Not really. No? It's very like died over there. It's like one of the old sections. Okay, Section 7D, the Maintenance Act empowers the maintenance officer to require maintenance investigator or the maintenance court concerned to perform such other functions as may be necessary or expedient to achieve the objects of the act. So here we have somebody with a sheriff, a guy with a gun and the powers to do stuff and to find stuff. If I don't know, that's the whole day in the office over there. So it doesn't make sense to me. So we have this beautiful piece of legislation on paper, beautiful, well drafted. Nice, Maintenance Act. It says people must do things, but when it comes to the operation or the application of it, it's non-existent. You know what I mean? It's like a guy writing a love letter to his girlfriend. You know, I love you and I'll do all this for you. Now she's in trouble, she's some money, he's missing. You know, so that's exactly what's happening over here. You know what I mean? Beautiful act, but maintenance officer was only there to me. Okay, but you're doing work, right, sir? Okay, so this is an important 7.2e. What can the officer do? Gather information concerning the identification, whereabouts of the person, liable, financial position of the person affected by any other matter which may be relevant to concern subject matter, or gather such information which may be relevant concerning the request, blah, blah, blah. So you also refer to the case of Isaacs, you know, it deals with that issue, and the case of NB, Mr. Maintenance Officer Butterworth. You have the cases here, then you can do whatever you have to do. There is a legal obligation upon the maintenance officer and the magistrate. This is the most important one which I tagged here, because the people in front of me was the maintenance officer and magistrate. The legal obligation is for them to conduct a thorough inquiry. The court should not play a role of an umpire. Many people do that. I'm an umpire. Okay, point 1. Even though they calculate the points, you got more points, you win. And here's this case over here of Mugabe. That's we have got the wrong. When parties are underrepresented, the maintenance officer must inquire into all the relevant aspects of the case. Here the parties were underrepresented, you know, so they had to inquire that. Furthermore, a passive attitude should not be taken by a judicial officer in a maintenance inquiry and then give judgment. Peterson versus Peterson. Old case. So from 1965 already, you can see the flavor, you know, what's happening in maintenance matters. Why are we judging from 1965? The problem still exists today. Like Felicity, still exists. Felicity will tell you, it still exists. Okay. There is an onus on both the maintenance officer, that's the day, and the presiding officer. I don't see the presiding officers here today, in placing evidence before the court. Butch versus Butch, 1967 already. Nicole, you know that case. You were not born that time. Felicity, were you born 1967?
3 years old.
Oh, exactly. She was 3 years old. Yeah, so it's quite an old case, yeah. This is the right law, and obviously it's the board says that it's the right law. Money held in pension funds should be attached when in the child's best interest. Okay? So Solar, another case of my Solar versus the maintenance magistrate. So that specific case over here, 2006. My client was struggling to get maintenance from his father. Okay? They were divorced. I think they divorced that time. And we were in the maintenance court, Weinberg Maintenance Court, and the father had a pension fund. He had money. He retired everybody has money. Money lies there. But we couldn't attach. I think we could have only attached on a monthly basis. So if he never paid, we can just go every month we can attach. So you run over years of 5 months and we attach that. But it's problematic because tomorrow something happens and he goes missing and he takes all the money out. So we took it to the Western Cape High Court, and the High Court in the Western Cape said, no, you can attach future maintenance. That's cool. But obviously, there's other issues regarding normal pension funds. You can attach for arrears. I think maybe we can challenge it one day, because I think the Maintenance Act, the Pension Fund Act, all must be changed to allow, if the guy got 10 million rand maintenance, pension fund laying over there, you can attach future from that. Take that money out. You put it maybe with a guardian fund or somewhere there so we can make it rateable over there. Because that's not good. Good, yes. Okay. The Maintenance Act further holds various provisions that are designed to and intended to ensure the recovery of periodical maintenance. Is versus hierarchy. So we say, oh, that's a Maintenance Act. You must use the tools, guys. We have tools. We have WhatsApp, we have Facebook, we have Instagram, we have tools. So use the Maintenance Act, use the tools. Okay. So this is where I conclude. So you can see where my angle of attack came over here. I'm attacking the system that took place over here. I'm not arguing whether the amounts is fair or reasonable. I'm arguing there was a mess up over here. That's what I'm going to do. Otherwise, I'll just regurgitate the facts, which many people draft in the heads of arguments, they do that. Okay, and leave it to the magistrate, to the judge to determine how to deal with the matter. It is common cause that the father has not adhered to the paying of the sum of 5,500 per month into maintenance. The maintenance officer should have been instructed. So who should have instructed the investigate the financial affairs of the father. Furthermore, should the maintenance investigator have done a proper inquiry as provided for in the Maintenance Act, it would have requested outstanding documents from the father before proceeding with the maintenance inquiry by the maintenance court. That was another issue over here. The matter should not have run around in the first place because the outstanding information wasn't there. Am I right? You can't run a half bogus trial. I must have all the information in front of you over here. We should not have gone to there in the first place. So in relation to the child, the monthly expenses were in the region of 20,000. The only documented evidence submitted by the father on the record was an email from the Christian Albert, from the pension fund. So the father comes arrogantly here to court and he says, I want to pay 100 rand per month, 150 per month. I own a house, I own this, I own that, I'm a lawyer and all those things, I'm a consultancy, but I must pay that. The parties might have issues, but that's not before me today. That's not my concern. In 2012, the sum of 600,000 was paid to the father. 600,000, what do you do with that money? The balance of 1.3 million is still laying there. The magistrate requested the money, the documentation, in order for you to make a decision as required in law. The law is expected from the magistrate. The outstanding documents would have assisted the court in determining the proportion of the child expenditure either party had to pay. I'm still in doubt. I don't know. Is that father, maybe it's worth much more. Maybe it's paying too little. Maybe that fund, that provident fund, the pension fund, the Gracia annuity fund is not correct. Maybe use up all that money. Then you must pay less. Am I right? That's only fair. But we don't know because nobody done the job here. Okay, the value of the immovable property belongs to the father, could really be high, placing the father in a much more favorable position than the mother. His monthly bond is 10,000 rand. So we can presume a bond of 10,000 million rand, stuff like that. The amount is an indicator as to value of the property. However, we do not know this. The bank statement of the father's companies could indicate the earnings and considerable monthly income. It's all plausible information. Nonetheless, a magistrate, knowingly that the documents were required, made its decision without considering any of them. So here the magistrate said, I need these documents. But a month later, he woke up. You know what? I don't need this document anymore. That's what he does. Okay, therefore, the magistrate did not give effect to section 15(3)(a) of the Maintenance Act and the child-based interest principle found in the Children's Act and case law and the Constitution. But I also see another flip side. On the flip side, the conduct of the magistrate is highly prejudicial to the father. It is. Remember, I'm not here against the father. I don't know the father. He may well not be able to afford the 1,000. It's possible. 1,000 award, which the court made without due consideration of his financial circumstances. The court has an obligation to look after both sides, man. We all know there's heated debates, husband and wife, mother and boyfriend, girlfriend. They come to court, they're angry. It's not the court's job here to be the part of the cloud and go to the mother's side, the father's side. The court must be fair. So even if the father is a waste of time, a deadbeat dad, he never sees the child, but he must only pay 100 rand, he must pay 100 rand. You can't make it 110 and to make the father suffer. That's not the law. The law doesn't work that way. Am I right? Does it make Felicity? You with me on that one? Felicity might say, no, face you bliksem. Yeah. And Felicity, say something. Okay. However, without any evidence as to the hearing and financial position of the father, such an order is improper when I refer to the Perry case. Maintenance award. Now, so I argued that the mother's income is 50,000 per month. Her student income comes to so much money. There's rental income. The expenses come to 1 to approximately. Yeah, so I'll just work on mathematics over here. Deliver assets, the bond outstanding amount. Okay, then I refer to the father, blah, 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 blah. I conclude. Okay. So the evidence provided is clear that the father is much more financially better position than the mother. Therefore, an order of 5,500 per month is fair. And then I just argued my final closing submission here. Oops. And then, so I say the following. It is therefore respectfully submitted based on the standard of learning of the parties, the needs of the child, and the means of the parties. The magistrate urging this award. This award should have been 5,500. Alternatively, if it is directed that the proper inquiry was not conducted and as provided for the act, then the matter should be referred back to the maintenance officer for proper investigation. Conclusion. So I asked for 5,500, and then alternatively it must go back. They should have been here. I was repeating. Okay, before the matter is referred back to the hearing, before the magistrate, that's important. The outstanding documents and any other relevant information must be before the court. That's just how it is. Okay, appeal must be upheld, and that was on the 24th of April. So that's a document.
You mean?
No, you have got 5,000. Yeah, of course, we're not paying. No, sorry. We won. No, so this is the judgment. It came out over there. No, we won. We won. We're not going to go to lose.
And then one question is really more than another. And the child is costing 25 rand. Why was it 25 and a half? Because that's not proportionate with the income.
The reason why I argued that point was because the mother requested 5,000. So I wasn't in a position to even argue more because we am coming to that argument. If the mother asked for 10,000, I would argue for 10,000. So it's just a logical thing. Otherwise, I look greedy. And my fees are the same. So whether or not she gets 5,000 or more, does it change the code? I saw invoice the code the same. Okay. So yeah, we wanted the court made an order of 5,000, but let me deal with the judgment quickly. So it's unfortunate that so basically the judgment has confirmed the legal principle which I mentioned. That's fine. But here's a part I highlighted. So I argued that part over here. Then this is what the court said. I'm in full agreement with the submission made by me, okay, as well as the need not dwell upon the judgment. As well as his criticism of the magistrate's approach to the evaluation of the evidence presented by the parties, which criticism is made by the maintenance officer regarding what the latter believed would be just and equitable award for maintenance. So he's criticized the maintenance officer as well. That's very important to note over here. He's not just blaming the maintenance magistrate over here. In any event, it is clear that the magistrate did not give effect to the underlying principles of the child's best interest. Very important. Okay, remedy. So this is what they thought was the best remedy here. On the issue of to be decided on appeal, it resides with the court. The court decides to determine what's the best and expedient remedy to accentuate the child's best interest. Very important. The court needs to focus on that. To my mind, the principle would be undermined conceivably by a delay. If the matter was referred back to the court of quo, either for further investigation by the maintenance officer and or further inquiry by the magistrate. The Maintenance Act incorporates several provisions which are designed to and intended to ensure the recovery of maintenance. To quote the sentiments expressed by Webster, that case over there, okay. The primary objective is not the wielding of awesome powers that a judicial officer are granted by law, but a dedicated and focused objective of the recovery of maintenance for the child. Court should be unswerving in their resolution in achieving this. Is that the factual case? No, it's not the factual case. You come to court over there, magistrates don't have time to listen to you, they're busy, they rush you, they force you into decisions, which is not obviously right. Okay, that was that. The respondent has not been maintaining the minor child for a substantial period of time. So here the court has restorative justice, which I loved about the judgment. Part of the background matter in the matter is that the mother didn't approach the maintenance court for years. She was fine, but now that she got ill and she's sick and stuff like that, she needed more money. So the court took note of that. And then, of course, the court made an order, so you guys can all look at the bottom of the order. I will not be here. I'll have to leave it because I've got some other work to do at the office. I think I've got another 5-10 minutes. If you have any questions, you can pose it to me now. Otherwise, I've got a few closing remarks. Anybody? So she went up before you. Let's get to it.
Sorry, can you just repeat the question so that the people online can hear this?
I'll do that. Thank you.
I don't even know to start to ask a question, but basically, being in an unemployment situation for a very long time, initially had a company, got sold, basically lived, I'm assuming, of the proceeds of the company for like 2 years. So there's a distinction, how do you distinguish between self-employed and unemployed? Because he was self-employed and not unemployed. The last, I went to the court initially because I had the years. That's kind of settled, but the problem is, while that case was still open, I submitted a request to a full financial investigation. None of that was done, and I only actually realized after the fact that the case was closed that because I wrote back to the NOS and hey, who was the investigator, what documentation did you get? Because I only realized that you made this, your decision, once again, based on this bank account and the credit card account and so on. She only on that day of her, what's his name, realized that they actually had an asset. And there's a lot of things, question marks, which I've emailed her about, previously saying, this doesn't make sense, it's a shares account, apparently, like, there's no answers to any of these questions. I then got told, I made the decision, you have no right to request an investigation as public. I said, ma'am, I gave you a letter signed by Walid Adams from the Public Prosecutor's Office on the 21st of April 2020. So it was actually, but anyway, the bottom line is that case is closed. So I don't know what to do, if I should. But now I'm going to court as a defendant because he's now applied for a decrease. Last time I checked, he's unemployed. I know now there is an attachment of the property. I mean, he does have a property. He's also director of 2 entities. There's no bank accounts of those entities. There's not enough financial. And I asked the court to please do a thorough check. So if you say he has no money, okay, fine, then we talk. But I'm not satisfied that there's no concrete evidence of his actual financial,
Yes.
Does he have another bank account, RAs, and all of those things? Because I'm looking through my file and I see that there's RAs from 2012, but I mean, So my question then is like, what do I actually do? Do I go in now and write all these things down and go with another letter to say we do a proper full investigation? And then how do you attach an asset or an RA or whatever? Because why does I always be making a plan to sort stuff out?
They should. So I'll deal with that quickly. So there's two prongs to this question. The first question is how do you distinguish between somebody who's being self-employed and employed when you get to that point? And the other one, obviously, some advice here as how to tackle this issue. That's fine. So I think the bottom line of it is, if somebody works for his own company, and that in effect means that this person is self-employed, and now he sells his company and he's not operating, that person is still self-employed. You see, that's a difference. If I own a company and I sell the company, doesn't mean I'm unemployed here. So he is still self-employed as being very lazy. So take it from this point of view. This is what I'm going to, man. Let's say in front of a constitutional court judge. I always do that. You think that constitutional court judge will think this is fair and proper what the father is doing? Not the magistrate, my court, they're lazy. With respect to anyone over there, I court judges are lazy sometimes. But don't think of it from that perspective. And if you feel that this unfairness and injustice taking place, you need to act on it further. So, okay, that's the first aspect. So he's obviously still employed. So I mean, I'm self-employed. Doesn't mean that I have a client tomorrow I'm unemployed. It doesn't make sense. It's kind of UIF thing, Sasa. I don't know. So that's fine. The other part of it is I see you have 50%. You got data in front of you, but there are 50% steps going forward in the sense of you've got provident fund, you mentioned annuity, but you're not actioning any of those things. But listen to me, where I'm going to over here. I think you just need to now focus on, forget about the maintenance officer for 1 second, find my maintenance code. Find out how to be there. I can't maybe give you the 1, 2, 3 advice to do that will resolve your problem for you. That will also be irresponsible upon me. It wouldn't make sense. But you have certain stuff. You know about this, you know about that. Like, think of yourself, give yourself a law degree. Give yourself an advocate cap. Just resume all that. How will I actually receive and find out and do stuff for me and not depend upon the maintenance officer, the maintenance investigator? Once you've done that exercise and done all those things, then you say, next officer, I've done my following research. And if you're not here to assist me, I'm going one step further. You must what Openman mentioned over there. Don't stop there. And what I love about Mr. Openman's presentation, a lot of stuff I heard now I didn't know about. I'll be honest with you. So actually, don't give up. So if you were inactive for the last 2 months, I don't blame you, I blame you. I tell that to my clients. Because if you do nothing, you're the one that's doing nothing. Don't expect the system to come assist you. The system is there to facilitate. They are there for to do whatever it is. I mean, I can't, if I want to open my bank account, I have a problem with the bank. It won't miraculously this happen. I need to just go to the bank and do something to make it happen. So when you are concerned, and I believe Nicole will tell you all the time, we deal with impossible cases, literally impossible cases, impossible, and more impossible than what you are saying now. But it happens and we get success out of it because we're pushing energy into that direction. We're not pushing energy there and saying, oh, I'm not saying you are doing that. So speak to us later on, but make it happen. You'll get. So I don't hear about. Nicole, sorry, let's give my number to her. We'll chat again later. That's fine. Is that fair? Okay, thank you very much. I'm going to deal with her. Yeah.
I'm referring to your where
Yes.
but then there's a governance model that is officer as well as the magistrate.
Yes.
Actually, properly.
You're right.
Obviously, you as the application for your own work.
Yes, you're right.
But say for instance, the applicant is legally represented, but in the opinion, the representative did not do the job properly. Will they still stand that the maintenance officer and the manager is actually also comes on them, and it should have done the financial investigation and it's on done, or would it be due to the fact that the applicant is legally represented? The others will actually be on them because there's no representation. If that makes sense.
Okay, so let's call it this. So this is where I'm going to. A maintenance matter must be differentiated between a normal civil matter. In a normal civil matter, the magistrate clearly sits here as an umpire. He gets paid to be an umpire. The job description is you are an umpire and you're supposed to umpire. In a maintenance matter, the magistrate gets paid his salary not to listen to an attorney, lawyer, whatever the case may be. His job is to be inquisitorial. That's his job. So if the lawyers are giving half-baked presentation, he still must bake the other part. Because he cannot say, I'm making my decision based upon the fact that the lawyers presented. He must also say, I listen to everybody, half-baked, full-baked, whatever, and I am satisfied that all outstanding data was presented to me. And that's the basis upon which I'm making my judgment. So you say the lawyers mess up, it doesn't affect the magistrate's job. That's so the question was, sorry, I should have repeated earlier on. Is the maintenance court responsible for the legal representation, the legal representatives' presentation of the case? No, they're not. They still have to do their own job and properly done. So if example, if the maintenance, if the attorney says, no, we're happy with bank statements for the previous year only. We do not want to see bank statements of this year. And we're happy to run the trial on that basis. The magistrate must say, I want it. I wanted to almost say something funny now, but I didn't say it. So that's how it is. Yeah. So.
I just wanted to add it on her question. She mentioned that she's a defendant now.
Oh, yes.
It's a blessing in disguise because he applied for a decrease. So now she can insist on a full financial disclosure because he's asking for a decrease. And all the issues that wasn't addressed in her previous application as an applicant, she can now actually insist and empower on as a defendant. He must give all the information so that it can be made a decision in terms of on what basis is he applying for the decrease. I think she should see it in that way. She has the opportunity now as a defendant to get to all of that information that she wanted to in the previous one. And she realized afterwards, okay, I actually missed this, or I didn't focus on this. So I think she should see it.
So I'll comment on that quickly. So what I like about Nicole's operation strategy is she'll tell the client, I need a case number. I can do nothing for you in this maintenance court matter until I get a reference from the maintenance court. Then she starts getting all the subpoenas and everything and starts sending it out. But the frustration the client you have is the following, that She's fighting it in this arena here. So even if she approaches the arena for her case, or he approaches that arena for his case, they just slap, finish already. Yeah, she repeated that, so that's good. So that's a problem we have in this case. So I'm saying over here is nothing is impossible. You need to believe that. When I met Felicity and guest, me and Nicole met her the first time 3-4 years ago. We met this lady that had this pipe dream over there. But you respect, and we all have pipe dreams. But she made impossible possible. We weren't here 3 years ago, but now we are here. The same way with you. Visualize and make it happen. I got 1, 2. I saw the lady first. Too bad.
Mine is a quick question. You mentioned ITC search. Now, on search terms, obviously, you could do a combined credit check. You'll get reports from all the credit bureaus. It's a lovely tool. But you need the consent of the person you're searching for. Are you saying somewhere in the Maintenance Act or somewhere you don't need the consent?
My answer to that question, quick, maintenance investigator does not need anybody's consent.
But he doesn't have search terms.
No. So if you can, maybe just give him access to it. Why not?
No investigators, they have to do what?
Now, I'm not here for the state. You would have sought them out.
So let's sort it out.
Yes. That was a quick question. Thank you. Quick question.
It's more of it's not necessarily a question, but it would be more an observation of what you discussed. Assuming a perfect world, then we have a very competent maintenance investigator. At the Section 6 inquiry, assume that in the perfect world that both parties bring all their documents together, and the parties between themselves are at loggerheads because, you know what, he left me for another woman, or as the case as what we know happens in family matters. And the maintenance officer in a perfect world now says, I've assessed all of this. I don't see the need for a Section 10 inquiry. Man or sir, this is a fair maintenance officer, a maintenance amount that you should receive. I've looked at everything, I've investigated, I've got all the bank statements, I've done the credit checks, I've done everything necessary. And because in an imperfect world, and because we know how these things happen, the woman says, I want 10,000, he's getting cash money, he does side jobs on the weekend. And the matter is not referred to a Section 10 inquiry. What would you say in that case? What would be the correct approach to that? I assume now I'm counsel, I'm representing my client, my instructions from my attorney is that you need to go into a Section 10 inquiry, the woman or man, whatever the case may be, wants to have an inquiry.
My quick answer, it must go to Section 10, full stop. And the basis for that, I'm saying the following. Constitutionally, you have a right to have your dispute heard in the court of law, number one. Secondly, the child's best interest. Everybody, all those constitutional rights, the matter needs to be ventilated and proper. The maintenance officer is a guy. He's not here, judicial officer. He's not here to make an assessment on the matter. It's not his job, number one, and his onus on him to make a maintenance decision over there. So if the act in any way limits that from happening, and I never experienced it yet. I know there's some people that interpreted that if the maintenance officer doesn't believe there is merits for it, it can't go further. But that's unconstitutional. It must go, it needs to go before a magistrate, an umpire. And the magistrate hears both sides of the story, the mother and the father, and he or she comes to a decision that's final, it's appealable. But how do you appeal a maintenance officer's decision? So you need to go to Section 10. Ms. Lawrence, can answer that?
Sorry, just a simple answer which I give my clients is the maintenance officer's calculation is a recommendation. We don't have to accept it. So for me, there's nothing stopping me from saying if my client still wants to go to trial, to say yes, it must still go to trial. The maintenance officer can't say it can't go to trial. He must refer it to trial if they don't accept the recommendation or parties can't agree on it. So it must go to trial for the magistrate to decide.
I understand. So the maintenance officer will largely then play the role similar to the family advocate.
A minimal role, let's put it like that.
Yeah,
yes.
Thank you.
My last comment, I am going to give my heads up arguments to them, and if you want to look at it, you can take it from me. And I believe appeals should happen. You should appeal. Please appeal.
Please just ask
Are they allowed to ask second question? Joking, let me come in.
Because my view is like a bully into something, you say, okay, fine, you pay for 4 months. Then the court pushed it up another 3 months because they're not available. Maintenance officers, you're not up there, they're not there. It gets pushed another 3 months. Then it ends up 7 months. Now what happens to all that arrears amount?
You see,
Does the woman become responsible for it?
No.
Appeal that outstanding.
This is my last comment on the Advocate Reuters. So in terms of the Maintenance Act, it's very important. Section 16 something, I can't remember now. There's 2 scenarios that applies. One, if there's no Maintenance Act in place, no Maintenance Act, I mean, there's a maintenance order in place, a final maintenance order in place. The court can make an order that the maintenance be payable from the date when the person stopped paying. Could be from birth, whatever the case may be. So in your case, if an interim order was made, if you want 2,000 rand, for example, and the interim order is 1,000 rand per month, until the Section 10 is heard, you can tell the court, now the court, under Section 10, the court makes an order that you're entitled to 2,000. But the court can make an additional order that you should pay 2,000 rand from the date, from your application, or from the date whenever you initially want the money. And also considering that he has been paying the 1,000 rand so far. The reason I'm saying so is I appeared in a maintenance matter in Wynberg Court, and then magistrate told me, senior magistrate told me, Advocate, we never even applied the section before, but he gave you the order. That's it. Thank you.
Thank you very much, Advocate Mohammed Abdouarif. I know I'm not pronouncing the surname correctly, but thank you so much for your time. Thank you, Ms. Nicole Lawrence, for your time too. I've read your cases, and I've got a lot of respect for the way you are changing law in South Africa. Those of you that want to read the whole case, page 38 of your handout, the whole case is over there. So if you want to read it from page 38, you can read it. The highlighted parts that the advocate referred to is on page 43. So the magistrate's judgment as well as the remedy that was referred to is on page 43. That's where you will get all of that information on. So please take some time and read it. The advocate did say that he will make available his aids of argument. So we will get the aids of argument and post it on our website in order for you to have access to it and see how he argued in that specific case. So this is just a judgment. So we will get the aids of arguments, and those two together will be able to give you better insight into how to argue any of those points of law. For now, Felicity will take over after the tea break. We'll have a 20-minute tea break. Those of you that want to have free coffee over there at the back and have some free coffee. Those of you that would like to go and purchase some tea or some other food and stuff can do it in the cafeteria. There are some light warm meals available, so you can go and get some over there if you would like to. There will also be some other refreshments in case you need some. But I just want to say again, thank you, Advocate Mohammed, as well as Ms. Lawrence, for your time. I know that you are pressed for time and will be leaving us, but thank you so much for your time. From the NPA side, I just want to say thank you to both of you. So for now, we'll have then a break until 20-minute break. I will call people when we're ready to proceed. Thank you.
Needing an update from 2019.
Oh, yes, that's right.
I'll take one of them to the 50 grade.
Yes, I want to do it.
Dion.
Yeah.
Yes.
That file has been missing now. Miraculously, they can't proceed the file as well.
No, we want you to be changed.
Listen, somebody get my head.
then blame me, because I'm the one that advocate in the Western Cape that if a maintenance officer do his work properly in terms of Section 15, and the court comes to a judgment in terms of Section 16, and it's a proper investigation that was done on what is the expenses of the child, what is the means of the applicant, what is the means of the respondent, then there's no need for a Section 10, because Section 6 says, at the end of Section 6, it says, may refer to the magistrate. So if we work on may refer, that means it's a discretionary thing. And I can tell you of a case that I dealt with where there was a Section 6 and I did the Section 6 properly. I got the expenses of the child, how much their total expenses were, and it was confirmed by the applicant and the respondent. Then I dealt with the Section 15 means of the parties. The applicant said that this is the amount that she is earning. The respondent confirmed it. Then I asked the respondent what is his means, and he gave all his means. The applicant confirmed it. Based on that, and advocate said it is a purely scientific mathematics that you do, and I agree with that. If you, number one, know what is the expenses of the child, and number two, you know what is the means of the applicant, number three, you know what is the means of the respondent, and you've got all of those covered. That's the reason why Section 6 says you may refer it. It doesn't say you must refer it. So if you don't must refer it, and you can show to the court, I'll do what we call Section 6 recommendations. In my Section 6 recommendation, and I can show you one or two, in my Section 6 recommendation, I will put everything over there, how I came to it, how I argued the different Section 15 requirements, the different requirements, and then I will come to a decision. So this is a Section 6 pro forma that I started to do. So what you do is you look at the means of the applicant, you look at whether they are good cause. I prefer always deal with a clean hands principle. Did he come to court with clean hands? If he didn't come to court with clean hands, then you don't deal with him from there onwards. If there is a reduction application, then you look at what is the Section 7 best interest of the child. Then you deal with the best interest of the child. And then towards the end, then you make a recommendation to the court. And when you do your recommendation, then you say to the court what must happen. Then I deal with Section 6, where it says that the court may, and I want to highlight this part of here. Section 6.2 says the court may institute, or the maintenance officer, after investigating the complaint, may institute. It doesn't say he must institute. So if that work was done properly, then I don't see a need why you should have a Section 10. And in all by the cases that I've dealt with, I always say that there's no need for Section 10 if I did my work properly. Because of that, I was taken on appeal in Stellenbosch, because I said, no, I'm not going to do a Section 10. In this case, I've done my work properly. The parties all agree to it, so why must we still have a Section 10? Later on, the respondent got some advice from another attorney and said, no, but this should have gone on to a Section 10 inquiry, and I do not agree with that. Luckily for me, in my case, the High Court agreed that it's not obligatory and it's not a must that there should be a Section 10 inquiry to be held, if I can show how I came to it. So then what I do is, whenever I do my Section 6 recommendation, once I've done my Section 6, then I will send it to the court, and I'll ask the court to either confirm the order or say, no, I don't agree with what you say, Mr. Maintenance Officer. Therefore, I want a Section 10. Here's the date. Summons the parties for a Section 10 in case they don't agree with all my investigations that I've done in the Section 6. So that's how I deal with it. So I do not agree that it should be a Section 10 in all cases, especially if the maintenance officer can show how they came to that decision based on Section 15, the pro rata means of the parties, and the Section 16 to show that it is fair and equitable. If you show it's fair and equitable, then there's no need for Section 10. And I'm willing to argue that in any court in the Western Cape, if it ever comes down to it. You've got a question? I'll get you now.
Maybe, but mine was just more of a comment to what you say. And again, it comes down to your recommendation as the maintenance officer. So your recommendation would not then be necessarily what the parties have.
Yes.
So then what Ms. Lawrence is saying is that the thing is that we have the right to go to court and have a magistrate further inquiry. So the maintenance officer may, the may part argument, the may part would be good parties, there's nothing in dispute. There it is, do you agree? Yes, there's a consent to report and go forward. If the one party says, look, I don't, I'm not happy, I'm sure there must be more, I want judicial further insight into this, then it's a must. That's how
Excellent. We're on the same page. I agree wholeheartedly with you. I do not believe that all Section 6 should be a Section 10. It makes a mockery of the justice system, especially if you can show how you got to it. So I'm completely with you. Yes, sir.
Just a confirmation, both parties agree, fair and equitable, consent, it's a 363.
214.
The consent is then afterwards not appealable. If the consent is done, and both sides,
excellent. That is the case where they consent to it. But let's assume that they are in the maintenance officer's office, and after listening to both parties, then the respondent didn't want to agree to the amount that the lady wanted. The maintenance officer had some inquiry investigations that he had done. After his investigations, she wants 5,000. The maintenance officer said to both parties, based on what you told me, I think 4,800 is fair and equitable, and they accept that. There's no J214 consent order that is drafted. It is based on the recommendation that the maintenance officer made. The maintenance officer will then take a J168 court order to the magistrate and say, Your Worship, I spoke to the parties, and this is what happened. This is the means of the applicant, of the child. This is the means of this is the expenses of the child. This is the means of the applicant. This is the means of the respondent. Based thereon, I found that 4,800 is fair and equitable. I spoke to both parties and the parties agreed to it. Therefore, Your Worship, make an order in terms of Section 16 on a J168 court order. It's not what the respondent agreed on, but based on what I said and based on what happened during the inquiry process, then he will maybe say, okay, then maybe it's fair. In that case, it's better than to rather get a J214 if the respondent submit to it and then have it to make sure that it's not appealable. What happened in my case is, usually they will accept everything that is being said there, but they want to get another opinion or somewhere else. And during that time, I'll say, okay, then we, in terms of Section 10(6), can make an interim order. So then what I do is I go to the magistrate. There is no interim order form. So the magistrate will rather make an order on the J168 court order form. So then the order is made on the J168 court order. When he comes back after speaking to senior counsel or to an attorney that thinks, oh, no, there's a way out of here that we can maybe get a lesser amount than 4.8, then that's what they will do. Now I already made my decision, and in terms of Section 6, I said it may be referred. I feel since parties agreed in the maintenance office, therefore I don't have to refer it. Now they come back and say, no, they demand a Section 10. If I don't want to do a Section 10, I don't have to do a Section 10 because of the pay scopes in Section 6. Therefore, I will not be compelled to do it. What the respondent and his advocate then did in the Stellenbosch matter that I'm referring to is they took me on appeal. The court said on appeal that it can't be in terms of Section 25 because Section 25 you can only appeal against a court order. You cannot appeal against the maintenance officer's recommendation, and they wanted to appeal against my recommendation. My recommendation is not appealable. It's only court orders in terms of Section 25 that is appealable, as long as you understand that concept. Okay. Yes, Peter, I'll give Peter an opportunity, and then I will give over so that Ms. Felicity Guest can do her part, and then I will finish off with Section 30, attachment of debt. Please, I put some of the snacks that's available in our cafeteria. Please support our cafeteria. He got up early this morning in order to be over here and make sure that at least I have another venue for you to sit in. and he gave all his time in order to be here and cook some meals for us. So please, may I ask that we just support the cafeteria guy, because he don't have to be here, but because we can't eat in here, that's why I asked him if he can't come and assist and have coffee and tea available. So I please ask for your support, for him to just to support him, even afterwards, after our session. If you feel like just having to go and sit over there for a while and have a meal or coffee, please support him for us. Yes, Peter?
The case that you were taken on review, I assume it's the same case where you were but hit over the fingers or what the wording?
Yes.
So with the
yeah.
consent of orders that's not appealable, right? It is subject to review, so it is reviewable.
Yeah.
So
yes.
then that review, to whom does that go?
Excellent. Mr. Peter, you could have been over here, he's asking questions that you already know the answer to, but let me just repeat what he said. So, in a case like wherever a maintenance officer make a decision, they should never use the word decision. A maintenance officer, they don't make a decision. A maintenance officer make a recommendation, Nakwanda. So whenever we deal with these cases, we do not use the word maintenance, Section 6 maintenance decision. I got hit over the knuckles from the judges. The judges said that I do not have judicial authority. I cannot make a decision. I make a recommendation. And therefore, I got a hiding from the judges. I also get Buxla sometimes. And after that, all my cases, I always make sure that I say Section 6 recommendation that I make and not a decision. Judicial authority vests in the magistrates, and they are the ones that make a decision. And in that case, it's not in terms of Section 25, it's a review process. In the review process, in the same way that the Section 25 appeal goes to the High Court, you will then do your review to the High Court in that specific case. Similar process as what Eugene explained earlier. Peter, can we just hold that question until Ms. Felicity Guest finished, or do you need to, is it imminent?
It's with regards to...
Okay.
I just wanted to know, in terms of what section would you apply
for the review
arrears with regards to your Section 10 subsection 6 orders, the interim orders?
Yeah. Yes.
If an applicant wants to apply maybe for the arrears,
okay,
there's the interim order from the date of which that interim order was issued.
Excellent.
How would the applicant go about doing so?
Okay, the question is, how do you apply where there's an interim order in terms of Section 10(6) and you want to apply for the arrears? How do you go about? Same way, Section 31 of the Maintenance Act says it's an offence and it's also an order. Even though it's an interim order, it's still an order. Maintenance order is defined in Section 1 of the Maintenance Act, and a maintenance order is any amount of money that is being assigned to a child or a beneficiary. Then if there's non-compliance with the Section 10(6) interim order, that's in terms of Section 31 of the Maintenance Act, and then you can go ahead with it. Just for those that want to attend next month and online, next month we will deal with Section 31 prosecutions. Mr. Eugene Opperman will have the floor and deal with the different prosecutions, how and what can be complained about criminally, and how we will prosecute those Section 31 cases, in how we prosecute the employer for not listening or honoring the garnishing orders. All of that will be dealt with next month. But let me just hand over to Ms. Felicity Guest. She will deal with the Potgieter case, and then I will come and deal with the Section 30 attachment of deed.
Hello, everybody. Nice to see that it's filled up a little bit more from earlier. Thank you all very much for taking the time once again to attend our workshops. Before I start on my presentation, there's so much that happens, and the one thing that gives people some kind of hope is the work that we do, and by being visible. And there's a lot of stuff that is also not visible. So the one thing is I started a petition in 2019 to petition, I think there were 33 demands. It's going to be presented to Parliament this week. So even things like that take time because it's finding the right people to motivate it to actually get the stuff heard. So that's the one thing. The other thing, there is an event in Cape Town where the regional head of Department of Justice is one of the guest speakers, and one of the things that he will be challenged on is a host of maintenance questions that Dion and I provided to a colleague who is part of that to present to him. And as soon as we get feedback from her, then I will share it. And I just want, because this is the kind of stuff that gives you hope. There is stuff, the wheels keep moving in the background, sometimes very slowly, but they do move. Where's my thingy?
Your what?
My thingy. Here's my thingy. Okay, so last week I presented on the Nell Potgieter case. And there's more to it. So I'm going to unpack it further today. Because there's always layers to the stuff. And a great part of my work is to create the awareness of the many forms of abuse that actually overlap and intersect with maintenance matters. And it's important to understand that, because if people do not understand the abuse, then you're just dealing with bits and pieces of paper and files, and they're just going to be moved around. And the family courts, unlike most of the other courts, is emotional. And part of our challenge is that the family courts all operate in silos. And I might have said this last week, but if I haven't, I'm going to say it now, is that there should be duplicates of every bit of information that is happening in a different court, because it is only through that that you actually get an understanding of the complexities and the urgency of cases. So if you have a case going on in children's court, and you have a case going on in the family court and in the domestic violence court, and it culminates in you having to approach the maintenance court for immediate relief, and if there is no perspective, the maintenance officer is going to look at it one-dimensionally and make a ruling that will not protect the victims. And the sad part is that the primary caregiver, who is normally the mother, is also a victim. But the Maintenance Act is premised on the protection of the child. But the child does not have a voice in the maintenance courts, and it therefore depends on its primary caregiver in the majority vulnerable, marginalized people who are women. And again, with the diversity in this country, we have women. We have white women who have inherent privilege, and then all the way down to black women who have always been marginalized and are still marginalized and still do not have the voice. So while our Act allows for all of this variance, as women in the space, and when we speak up, we need to be cognizant when we speak on behalf of women. And we should always speak and think from the position of the most vulnerable of society. And it's important to understand this, because I'm now going to start speaking about the background stuff with the Potgieter case, Potgieter Nell. And part of the prejudice and the harm is the lengthy processes to finalize maintenance cases with a fair and equitable agreement. And that is the space that the financial abuse accelerates and compounds and causes more harm. And I'm speaking through the divorce lens initially because they got divorced, they were married. But from here on, for most of the stuff, it applies to anybody accessing the maintenance courts. So just to recap, Potgieter was found guilty in a maintenance criminal trial for not adhering to a court order issued in 2012 and incarcerated for 4.5 years in 2018. He appealed the sentence, lost his appeal in August 2021, and is now serving his sentence. That was the original timeline. What I have done is I've now highlighted, just to give you an idea of the different people and the different things that were at play. So if you look at the purple, May 2009 is when he served divorce papers. And then if you look at the next purple on the timeline, it's 3rd of August 2012, when the divorce was granted. And then if you look at the last one, 12th of August 2021 is when he lost his appeal. So you can see between the two purples how much litigation took place that had very little to do with, in fact, didn't have anything to do with maintenance, the maintenance court. And then there was the bulk of the maintenance litigation happened between 2012 and 2018. And you'll see now how many days that was. So if you just look at the different colors, the yellow is applications for protection orders by Potgieter. And not a single one of them were upheld. Every single one of them were dismissed. That speaks to coercive, controlling, and manipulating behavior, using the court as a tool to cause further harm. The pink is Nell's one application in this time, and that was to apply for protection or Rule 43. I'll cover that a bit later on. The grey is Potgieter's malicious behavior to limit her access to finances. And that's part of the behavior to prevent the other person from having equitable representation through the litigation process. Because if the one person runs out of the financial means, they're immediately at a disadvantage. The yellow ones, the green ones, are all the times that she was arrested and spent time in jail as a result of the protection orders. A lot of the time she was arrested in front of her children. The one occasion she was driven off the road for an arrest to take place by a metro policeman who happened to be a relative. These are all intimidation tactics. And we hear women tell their stories that they can't tell in a maintenance court because those belong in a domestic violence court. But if the perpetrator is intentional and strategic about it, he is always one step ahead. And you are always, as the victim, you are always being reactive. And what impact does that have on a victim? You're constantly having the wind punched out, and then you have to recover, and you hardly recovered when you receive another blow, which eventually wears down the emotional capacity to think rationally, and to stand up courageously to carry on fighting. And it's therein that women give up. And it's understandable. And where we come in as a support is to encourage them, to hear them, to acknowledge them, to validate their feelings so that they can carry on. Approximately 33 appearances between May 2009 and January 2013, excluding maintenance court, all of which are not on the above timeline. A clear case of vexatious litigation, which constitutes constructive financial abuse. 365 days from 2009 to 2015 in various maintenance courts. That's how much time Louise Nell spent in maintenance courts. She lost a year of her life. And she was trying to have her and her children's rights to maintenance enforced. She was awarded rehabilitative maintenance. In Section 28 of the Constitution, every child has a right to family or parental care. How could she care for her children when her hands were cut off financially? How could she care for her children when she could not warm food up for them? How could she protect her children and provide for them if she could not even provide the basics of water and food for her children? To basic nutrition, shelter, basic health care and social services, to be protected from maltreatment, neglect, abuse or degradation. On that same timeline, these are the only things, other than the ones on the extreme right, that actually had anything to do with maintenance. Those are Nell's files. For all the other litigation as well as her maintenance files. One person's. You can imagine how much energy and effort it actually took her to have to deal. If she's provided that much paper, it gives you an indication of how much litigation she actually went through. And there's more to be added to that, and that's probably not all of it anyway. What should have happened? So Potgieter served divorce papers on Nell in May 2009. After a couple of months, it became apparent that he wasn't going to contribute anything financially. So Nell approached the maintenance courts. They were awarded an interim maintenance order. He didn't comply with that. And then an attorney advised Nell to take out a Rule 43, which she did at a huge cost, because that was still the early stages. She still had some finances. Now, non-compliance of a Rule 43 would have been remedied through the maintenance court in any event. And in fact, the interim order made by the maintenance court was the exact same order sanctioned by the High Court in the Rule 43. Section 10.6a, a maintenance court shall conclude maintenance inquiries as speedily as possible and shall ensure that postponements are limited in number and in duration. If procedure and processes had been followed as prescribed in the Maintenance Act, there would have been a very different outcome, much different to what Nell experienced. So this is what should have happened if the maintenance courts were acting in the best interest of the child and adhering to procedure and interpreting implementing and enforcing the Maintenance Act as it should have. So Potgieter serves divorce papers. He doesn't contribute financially, so now applies for an interim maintenance order, which is granted. He defaults on the maintenance order, so you'll notice the purple is Potgieter, the white is the court, and the pink is now. Show variants thereof. So he defaults on the maintenance interim order. So in January, Nell could have approached the maintenance court and lodged a non-compliance. In January, that's being gracious. 3 months later, they should have appeared in court. In April, Potgieter agrees to pay the arrears and adhere to the maintenance agreement by agreed timeframes. Okay, this is hypothetical. But this is just another tactic. It's taking that into account. He has no intention of adhering to it. So it's making allowances for the coercive, controlling, and manipulating and intimidating behavior. So he doesn't comply to that. So again, in the July, just 3-4 months later, now could have approached the courts to lodge another non-compliance application. Court issues a J306 and Potgieter is informed to appear in court in the October 2010. Just be mindful of these time frames. October 2010, they appear in court. Again, Potgieter promises to pay after being informed he will face criminal prosecution. January now reports non-compliance of maintenance order. The court issues an attachment order in January 2011 because now there's a history of non-compliance and his behavior. And the court goes, okay, we've actually had enough. So now we're going to issue an attachment order. So the court issues an attachment order on Potgieter's personal bank account, to freeze his bank account. Because up until this point, with all the other litigation, he has excluded her from the joint bank accounts. He has managed to wrestle the joint company away from her. And in between order, they sold it to his new fiancée. So all they could really attach is his personal bank account for the arrears. Potgieter applies for a suspension of the attachment order in March 2011 because we've seen this, he has a habit of appealing everything. In June 2011, the suspension is denied and Nell has paid out the arrears from his bank account. So we're down to 2 years and she's got money. Compare that to the first timeline, where she was still in the thick of litigation and now run out of money. In August 2012, the divorces grant is finalized. Again, in November 2012, Nell reports non-compliance of maintenance order. And then the criminal trial would start in 2013 as opposed to 2015 on the previous timeline. And 3 months later, he's found guilty. In July 2014, giving him just over a year's grace for the appeal, he lost his appeal and goes to prison. That would have been July 2014. Whereas on the previous timeline, it was only concluded, he lost his appeal in 2021. The emphasis here is on the timeline. So if the maintenance courts worked as purposed, you can see Nell would have been in a completely different position, not just financially, but emotionally and psychologically as well. Because she would have felt supported by the maintenance courts. Her children would actually have been protected. But she was thrown to the wolves. So why was the previous hypothetical ideal not realized? The lack of training. Nell was never guided by any of the maintenance court staff as to what recourse was available as stipulated in the Maintenance Act 99 of 1998. She relied on Google. She asked friends for advice. She used common sense in what she thought she should do next. But she never gave up. She felt unsupported and never felt there was any urgency to assist her and her children. And interpretation, implementation, and enforcement was not coherent. The lack of understanding of domestic violence, particularly coercive, controlling, and manipulating behavior, contributed to the lengthy time it took. Because his behavior just changed post-relationship, and his playground became the courts. So his behavior changed shape and form using money. Lack of training in understanding and being able to recognize abusive behavior, which plays itself out in the maintenance court. Postponements caused irreparable harm to Nell and her children in multiple ways. The abuse is silent, but no less violent, which impacts not only on the victim, but society at large. Because when Nell was arrested, she would phone a friend. When Nell was homeless, she had to ask somebody to take her in. When Nell lost her car, she had to ask somebody to pick up her kids. And this is the impact that it has on society at large. Differently, but it happens. So it's not just the victim that is impacted. And take this times 50 in one tiny community, and you can understand the levels of anxiety, depression, post-traumatic stress disorder that people are living with in community. Oops. What happened there? So I worked out an estimated cost to Nell through the negligence of the maintenance courts. So I worked out at approximately 1,500 Rand per day that she spent in court. And that is conservative for what Nell's earning was at the time of the start of litigation, which came to 547,000 Rand. That's what it cost her just being in court for 365 days, plus transport, plus printing, and I just put a figure there of 3,000 Rand, just for the sake of realistic numbers. So that's what it costs now to approach the maintenance court. These are unhidden costs that are never taken into account, that contributes to the financial and economic vulnerability of a person who is already desperate, who is approaching the courts for immediate help. But they are further abused by the system and compromise that just makes the vulnerability greater. And the maintenance courts is there to prevent this, yet it's the cause of more harm. So if we just extend that a little bit further and look at some real costs. Sorry, I just want to get my phone because in the transfer of the files, I've lost a whole lot of information there. And this is what it costs now. The lengthy periods of litigation and where it harmed her instead of protecting her. She lost her motor car. She drove a top-of-the-range Mercedes-Benz, and when she met Potgieter, she owned the property. She owned a car. She owned a business. He arrived with 2 suitcases. Okay? So she lost her Mercedes-Benz, valued 500,000 rand. She lost her house, which from the time that they got married and they upscaled, because he wasn't working, he started working for her. Yes, he did contribute, but he upscaled. And when they bought a new house, he convinced her to give him to register the house half in his name. They were married in antenuptial, okay? So she lost her house. 3 million rand for the house. She lost all of her furniture because she had no money and she had to move around. R500,000 rand it cost her to store the furniture when she had to leave the matrimonial home and to move it around in different provinces several times, and then eventually sold it off just to be able to keep living. She lost her retirement, which is approximately 5 million rand. Medical cover, approximately 300,000 rand over that time period. She lost over 9 million rand, over and above the 500,000 rand that it cost her accessing justice. Does any of that make sense to any single person? And I use this as a very public case, and I use this just to show how dramatic the impacts are of non-compliance of maintenance officers and magistrates in the maintenance court. And this impact is exactly the same for every single other person accessing the maintenance courts, at some level or the other. So, what do we hope that the maintenance officers, maintenance investigators, magistrates, court managers, anybody who works for the Department of Justice realizes from this? That they are in violation of not just the mother, but more so the child's constitutional rights. Every single time. It's impossible for us all to take the stuff on review and appeal. But this is a system that is built. It's become an amazing industry. And it doesn't stop in maintenance, it spills over into co-parenting. Because if he can't punish you enough financially, he will eventually say, you cannot look after the child and the child now needs to come and live with me. And the ultimate punishment for a mother who has carried a child and looked after it as a primary caregiver is to remove the child from her care. Unjustly. It's a crisis. And I know a lot of people think that I'm dramatic. This is based on reality. I'm not making this stuff up. And it's incumbent on legal practitioners to understand this. How can you protect your clients if you do not understand the abusive behavior? How do you protect your clients if you accept postponements and just keep communicating with his legal representative and racking up bills that 90% of the cases that the applicant has borrowed money for? And in the end, not many even go to court with their legal representative because they've run out of funds. And even then, they still do not get a fair amount of maintenance. And they never ever recover what they've lost. And this is the grey area of from the start of the application until the end. Everybody has control over this grey area. There's a start and a finish. And the people who are there to protect the most vulnerable of society, paid or unpaid, you are obligated to protect. So I developed a scale of financial abuse because all of this is abuse through money, which is financial abuse. Just to put it into context, there's an international scale of economic abuse. And as I've said before, economic abuse takes place in relationship. Financial abuse is how it changes shape and form post-relationship because money is the tool. So if you can answer yes, if somebody going through the maintenance court, how many of these can you answer yes to? Do you have a court-ordered maintenance agreement? Is money immediately cut off when the relationship, rephrase it, was money immediately cut off when the relationship ended? The father has the financial means to pay but refuses. The father said, you must go to court and he will pay child support. Sorry, the father said, do not go to court and then I will pay child support. And then when you don't go to court, he doesn't pay child support. The father deliberately caused or causes postponements. The father pays for children or a child that is not yours, his new partner's child. The father does not pay the amount stipulated on the court order. So if it's 1,000 Rand, 1 month he'll give you 900 Rand, the next month he'll give you 500 Rand, and the next month he might give you the full amount again. The father does not notify you when he will not be able to pay as required. The father blocked you from communicating after you asked him a couple of times when you're going to get your maintenance. The child support percentage is not proportionate to income. The father hired a lawyer to fight for less maintenance. The father stopped paying child support when he met a new partner. The father refused to pay an amount. Instead, he said he will buy what the child needs. The father demands slips for all money spent on the child. The father transferred assets out of his name to reduce the value of his assets in arrears claims. The father claims unemployment and earns cash to avoid a record of his income. The father deliberately resigned from his employment to avoid paying child support. You have to remind him to pay child support. Okay, so what I want you to realize about all of these things is, one, it's to keep you in a state of anxiety. He'll pay, but when it suits him, and that is the control aspect. He controls the money. He has the power. We see this. How many court dates, your maintenance orders are normally payable by the end of the month. Then the court still says you've got 7 days. So he knows he doesn't have to comply with the court order, but he can pay on the 6th day. But guess what's happened up at that point? Your debit orders are bounced. You get a bad credit rating. That speaks to economic abuse because it limits your economic opportunities. Go for a job interview, you've now got you're blacklisted. You can't get credit. So if you do manage to get back on your feet and you want to buy a house, because research shows us that the father still lives in the matrimonial home or similar. The mother has moved in with family or friends. And it's far more common than we like to believe because women, because of the insecurity, they cannot get a place of their own, especially if there's no maintenance agreement in place. Especially if you come out of a relationship and you weren't working, you've got to provide 3 months bank statements. So this is the vulnerability of women and children. So It's the behavior here. It's using the money, as subtle as what it is, but paying on unpredicted dates. That keeps a victim in a perpetual state of anxiety. How am I going to feed my kids? They needed to go on a school outing. I am short. I don't get financial support. I borrowed money and I promised at the end of the month, or as soon as my court order is granted, I'm going to court in a week's time. I'm going to definitely get a maintenance order then. It doesn't happen. You fail to pay the money back. Next month, you're in the same situation. Who are you going to borrow from? Because now the story's gone around. I don't lend her money because she doesn't pay it back. Can you say this in court? Do they understand when you go, I am absolutely vulnerable. I cannot take another postponement. I've got a loan shark that I'm now borrowing money from, and they're going to break my legs. Or they're going to kidnap my children because they don't care. They just want their money back at a completely inflated interest rate. These are all compounded things that impact on the most vulnerable of society, and then we speak about protecting them. That's what the Maintenance Act is supposed to do. And I believe that every single person who goes to the maintenance court should actually fill in one of these forms. It's how we're going to change. It's how we're going to educate. It's how we're going to create awareness of patterns of abuse. I'm not going to go through this again. This is from last month. But what I do want to emphasize is non-negotiable rights. Human dignity, equality, and children. And when a woman is fighting like Nell did, where is the equality? Where is the dignity? And where were the children protected? The preamble of the Maintenance Act says, to establish a society based on demographic values, social and economic justice, equality, and fundamental human rights, to improve, not make worse, the quality of life of all citizens, and to free the potential of all persons by every means possible, including, amongst others, by the establishment of a fair and equitable maintenance system. Nothing equitable about our maintenance system at the moment. Section 10.6a, again, postponements limited in number and in duration, and concluded as speedily as possible. And if we look at the now time frame, from what it was to what it could have been, we can see why. It needs to be limited in duration. This is Louise Nell's message to the DOJ. The department is failing women and children. The system does not protect those seeking help. Many women's lives are falling apart, and the staff are indifferent and unhelpful, and delays and exasperates the vulnerability. Nell and her children were homeless and suffering, yet the court did not see it as urgent. They do not explain the process, and the courts are overwhelmed. The staff need training urgently in order to realize the purpose of the Maintenance Act and protect the most vulnerable, who are women and children. Sorry, this is Nell's message to mothers going through the system. Join support groups and become knowledgeable. Ask for clarity. Do not expect to get it from the maintenance courts. We've heard this. Advocate Mohammed said the same thing. Make copies of everything. If you can't get copies, take photos and save it and print it and put it in your files. Keep records of every single thing. Take names of people that you speak to. Complain to management if you are not happy with the way that your case has been handled. Follow up on your cases. Be courteous to the people at the court. Don't give up. You will encourage others to push through, and your children do not have a voice in the maintenance courts. They depend on you to be their voice. DOJ needs to fix this broken system. We cannot protect women, irrespective of how amazing a GBV NSP is. Not paying financial support or not getting is a form of domestic violence. Sadly, it is not mainstream enough, but it's up to us as well to keep speaking about it being a form of financial abuse. And at the same time, trying to educate every single stakeholder who works with children, with women, with vulnerability, with policy, in equity, in job creation. It has such far-reaching impacts. And it's up to all of us to start learning more about it and advocating. The Domestic Violence Act Amendment Act is supposed to come into law next month. Maintenance is mentioned several times in that, but we know what's going to happen. Because there is no training, it's there because it's a form of domestic violence. But you go to the domestic violence court and just mention maintenance, and they go, sorry, you need to go to the maintenance court, because they're all operating in silos. But the biggest thing is, so the law's there, we're going to go, yippee, let's go and do this, but they are not trained. And you're going to be turned away from the domestic violence courts. And if that happens, you need to document it, you need to complain through us, because we have strategies that we are going to be tackling this. And again, it speaks to the consistency is lack of training. And the compound lack of training has on the most vulnerable. And I just wish that we could do a, what's the word? All of us get together. Huh? No, that also, lots of those. No, we
Burn down Parliament.
No! A class action. Thank you all. I just had to find it. I wish that we could have a class action about maintenance, but we can't because it's too nuanced. There's too many different factors. But we need to have a class action of sorts. 1, 2, we need to set a precedent about constructive financial abuse, because that will change the game. Because just like with Mohammed Singh, the courts will be scathing. And we need to have a summit.
In the revised Domestic Violence Act, they're now making provision for protection orders for financial abuse. How do you think that's going to make a difference?
It's not.
In the case of Nala, she was arrested several times for violation of protection order. So the abusive mom has a protection order for financial abuse, and he violates my mom's pay. You can have him arrested.
Okay, so you can't get a protection order for financial abuse because there's no such legal definition. You can get a protection order for economic abuse. You can get a protection order after June for for not adhering to interim maintenance. But you will be lucky in the first place if you get an interim maintenance order in the domestic violence court. 1. 2, I have a protection order for economic abuse. And then I couldn't, when I first went, they did not want to have him arrested. I had to take my investigating officer to the domestic violence court to have him educated. It was a whole long story. I don't have the time to go into it now. He was eventually arrested, and then it was beautiful. We sat around the boardroom table with the chief prosecutor, and we ended up singing Kumbaya together. His warrant of arrest was withdrawn, and he went clapping because half the arrears was written off. And we did. And I reduced my maintenance by 13,000 Rand. Just to get rid of him, just to stop this process. Long story forward, he's been in violation 4 times since then. The second time I went back, they refused to issue a warrant of arrest. They told me to go to maintenance court. I reported SAPS because I was abused at SAPS. I reported SAPS. They were investigated. They were found not guilty. In fact, that's not quite concluded because I escalated. 3 years on, I'm still waiting for a report from Western Province Head. I reported the two magistrates, and nothing has been done. Nothing. They've never come back to me because they stuck with their thing that this is a maintenance court issue. And let me just explain this. This is not a cent is for me. It's to protect my neurodiverse child who needs protection for the rest of his life. So it's not even for me. That's how they care for the marginalized and the vulnerable. And that is my concern of what is going to happen with the provisions in the amendments, because nobody is trained, nobody understands this. But we need to report that, and we will train, and we will keep fighting. It's going to take time, but we have to insist on this. Thank you.
Right, thanks, Felicity. That was great. Just a word on the Domestic Violence Amendment Act. There's actually provision where they make provision for it's actually abuse, or it's an act of domestic abuse if you expose a child to abuse, or if a child experiences a domestic abuse. So financial abuse, if the father is not paying maintenance, I'm sure that we can make out an argument in court to say, listen, you know what, a child is being exposed to a domestic act of domestic violence, and therefore you would get an order. I would see that in the near future, like Felicity said, is that the domestic violence courts will be bombarded, and rightly so, with applications for domestic violence in order to circumvent or to fast track the maintenance. Right, next up is Advocate Reuters. And then afterwards we will have time for questions and answers.
Okay, last month we did a section, or we are busy with civil attachments. So where we are in the system is the applicant was at court. The applicant applied in the maintenance court for a maintenance order. She got the maintenance order, and now there is non-compliance of the order. So what will happen from there onwards? That is where we are in the whole process now. So a J101 or J107 maintenance application form was issued. The respondent was then summoned to court first on a Regulation 3 directive. After the Regulation 3 directive for Section 9(2) summons would have been issued. After that is happened, then the applicant and the respondent will be in front of the maintenance officer. When the parties are in front of the maintenance officer will give introduce himself and will give a form called the Rights of Parties form. That's on page 79 of your handout. And with the Rights of Parties forms, the maintenance officer will explain to the respondent and the applicant that in the case where you change your address, where you change your employment, please inform us. If you don't, it's a criminal offense in terms of Section 34 and 38 of the Maintenance Act, and you can be prosecuted for it. After that, the maintenance officer will ask the most important question to the respondent. Do you confirm you are the father of this child? And complete a form called the confirmation of paternity form. That's on page 80 of your handout. Those are the most important things that happens prior to where I am going to then continue. He admits the paternity, and then he makes an offer, and the offer is accepted by the applicant. Then a form is completed. It's called a J214 consent order. We've dealt with the J214 consent order. That's why it's not in your handout, but you will find it on the DOJ website, or you can find it on the website www.childmaintenance.org.za. You can find all of that on the. If a 214 consent order wasn't issued and it went to a Section 10 inquiry, then the court will make a decision. The court will make a decision and will issue an order, and that order is then done on a J168 form, and that is the court's form where both parties didn't agree to it. The applicant didn't agree to the amount, the respondent didn't agree to the amount, and the J168 order is being issued by the magistrate. The respondent did not appear in a case where the issue or summons was issued on a Regulation 3 directive or Section 92 summons, then a J252 default order can be issued. If a J252 order wasn't issued, it will be a J168 court order or it will be a J214 consent order. Those are the orders that is being used in the maintenance court. Except for that, there are other orders too that is not mentioned. If you get a divorce order, that's also a maintenance order. In the children's court can make a contribution order. In a case where the child is put in foster care, then that specific order is called a contribution order, where the biological parents have to contribute to the well-being of the child with a contribution order. Or in terms of Section 33 of the Children's Act, the children's court can make a parenting plan enforceable with a Section 33(1)(c) order, which is an order for maintenance. So there is this nuance going out there that is only the maintenance court that make maintenance orders. That's not true. A children's court can make those orders. A divorce court can make those orders. Even a bail court or domestic violence court can make those orders. And hopefully, with the amendments that is happening in the domestic violence legislation, in future domestic violence courts will be more open and susceptible to make these type of maintenance orders. But I don't want this premonition or this nuance going out there. It's only maintenance orders that is made in a maintenance court. That's not true. That's nonsense. Any court, Section 16 of Section 16(2) of the Maintenance Act is clear. Any court can make a maintenance order. It's not just a maintenance court that makes those orders. Please, if you have learned anything today, then it is that any court can make a maintenance order, and it is not just a maintenance court. Divorce courts already do it with the divorce orders. Children's courts can make those orders, and in the next few months, domestic violence courts will also be able to make those orders. So now all of those orders are there. So what happens next? The respondent default on any of those orders. Then what is the rights and recourse that Mr. Opperman explained earlier, except now for complaining about the rudeness and all of that they swear at you and all of that. I like that one about Parliament burning down, but I didn't say that. It's not me. It's not me. It's Eugene Opperman that said that. It's not me. So I just wanted to go out there onto the online system, because it's not me. The NPA want to exonerate themselves from any of that. We didn't know Mr. Opperman is going to say that, so I just want to clear that part. So the respondent now defaulted in action. He did not comply with either a Section 10(6) interim order. That was the question earlier. What happens in the case of a Section 10(6) interim order? Mr. Eagle asked that question too. In those cases, even if it's an interim order, it's an order. Maintenance orders are, whether it's an interim order, a contribution order, a divorce order, whatever order, it is enforceable in our courts. And in terms of Section 31, you can go for prosecution, or else you can go for the civil routes that I will explain now. So the applicant or the complainant will then complain, and the form that you will complain on is called the J470 complaint form. You'll find that on page 47 of your handout if you want to see how the J470 complaint form look. In the case of an interim maintenance order, that is the form that you need to complete. Complete the J470 form on page 47. Now the complainant have a choice. What does she want to do? Does she want to pursue civil remedies, or does she want to pursue criminal remedies? She's got that choice. But even when she makes that choice, she can do both. There is this thing going out amongst or in the whole of South Africa where people are saying you must choose one or the other. That's nonsense. You, in a case where you pursue the civil route and you attach his emoluments and you got a garnish order, there's nothing that stops you from going to the NPA in the prosecution and tell the prosecution, I want to still prosecute this matter, even though I've got my garnish order in place. So what I want to tell the public, as all of you sitting here, if you complain and you decided on a J306 civil attachment on the J306 civil attachment on a emolument garnishing order or the salary of the person in terms of Section 28, right, with the provisions of Section 16(2) of the Maintenance Act to get the emoluments attached, or you decided in terms of Section 27 to have his TV attached or have his car attached or whatever you want to attach, that's all in terms of Section 27, and you made that decision, then you can still, at that time, decide, I want to still have a criminal prosecution in terms of Section 31. So you can have both. So even if you completed the J470 and the J306, and you decided, I want to attach his assets in terms of Section 27, you can always be asked that you still want that person to be prosecuted. There's an affidavit in the handout where I've been showing you how you complete the affidavit, and that's in terms of Section 27 of the handouts. I'll get to it now, which page number it is. Just give me a second to get there. So you can decide on both civil as well as criminal. Once you've decided on which civil remedies you use, you decide in terms of Section 26 whether you want a garnishing order, Section 28, or whether you want assets to be attached, Section 27, or whether you want to have Section 30, retirement annuity. The lady over there spoke about retirement annuity. We do that in terms of Section 30 of the Maintenance Act. On your J306 in the middle, there's a place where you have to pick which one you want. If you want a garnishing order, then it's attachment of emoluments. If you want to attach assets, then it is attachment of assets in terms of Section 27. If it is a retirement annuity or any of those pension funds or anything like that, then it's in terms of Section 30 of the Maintenance Act that you will make that decision. When you go and complain about non-compliance by a respondent, in most cases, when you come and you want to get the J470, maintenance clerks in South Africa have this thing where they ask you, hoeveel dae is it now, how many days is it now that you're waiting? That's nonsense. If you want to file a criminal case against a defaulting respondent, it's immediate. You do not have to wait for criminal prosecution. The only exception to the rules in terms of Section 26 of the Maintenance Act, where you have to wait 10 days, is the only exception to the rule. If you want to attach assets, if you want to attach garnishing emoluments, or if you want to attach retirement annuities, you have to wait 10 days. That's in terms of Section 26(2)(a) of the Maintenance Act. So if you look at Section 26(2)(a), you'll find that thing where it's the only place where it says you have to wait 10 days in order to get it. Unfortunately, the maintenance clerks and maintenance officers in South Africa decided to use it. Okay, nee mevrou, jy kan nie nou al klaar nie, jy moet wag nog so 10 dae before you can come and complain. That's nonsense. You can complain immediately in a case where there is non-compliance. If the child has to go 10 days without food, you'll see that malnourishment kicking in and the bones kicking in. So before that happens, then you attach the emoluments of that specific person. You do not have to wait. So if they ever tell you that, no, it's not 10 days yet, they ask you, where does it say that? They're going to show you Section 26(2)(a), but Section 26(2)(a) deals with civil attachment. It deals where you either want emolument attachment, or you want to have the retirement annuity attached, or you want assets to be attached. That's not what you want. You want this guy to be arrested for non-compliance of the order. While they are busy arresting him, and they arrested him, they can always say, okay, no, I still want to have my emolument attachment. I changed my mind. Where's the 306? Give me the 306, and you complete the 306. But immediately, you can get a criminal action being done against the person. Okay, so that was just the introduction. So this is where we are now supposed to start. In terms of Section 30, we can do what we call the attachment of debt. And I'm also going to deal with the future maintenance matters. So I'll show you how we can attach pension funds or retirement annuities and other benefits. And also, in a case where you want to attach his pension, you do that and a big amount will then be attached. That big amount will not be paid out to the applicant at once, because now if she all of a sudden gets 680,000, I always wanted a Land Rover, now I'm going to go and buy a Land Rover, or whatever the case might be. So before you start thinking that, oh, nog lank Spain toe gegaan het, to go and walk the Alchemode or whatever those walks are, then you want to do that? No, that's not the purpose. It's for the child's purpose that it's there. So therefore, we will safeguard the vested interest of the child, and we will put that in the Guardian's Fund at the Master's Office. The head of our Master's Office in the Western Cape is Ms. Advocate Zorina Agallis. The deputy in that specific unit is Advocate Vianney Lali. He was here last month, and he explained how the Master's Office deal with the Guardian's Fund, where they keep that money in a case where a big amount of money has been attached. So whenever an applicant comes to court and she says that this guy is in default, he either got retrenched or is getting his pension fund paid out, that should immediately alert the maintenance clerks to action. Why? Anna Mutimunia. Eugene earlier said Anna Oma Mutimunia, and Ms. Natasha still will quote Anna Mutimunia everywhere on all the websites and social media sites, but that is the case that I would like you to read. If you do not have a copy of it, please go on Safli. If you go on Safli on Google, S-A-F-L-I-I, Safli, then just put in, but you need to have the correct spelling. If you have one word out, you're not going to get the case. Get this specific case of Anna Mutimunia, because what happened to this lady is what happens to most women in the, almost in the Western Cape. It's not just the Western Cape, it's all over South Africa. When they go and they inform and alert the maintenance clerks, listen, this guy is getting his pension paid out, or he got retrenched, or whatever the case might be. Somehow Anna Mutimunia did not come through to everyone in the maintenance courts, because if they were aware of it, that should alert them immediately to action. Because what the judge said in Anna Mutimunia's case is the Department of Justice as well as the NPA is liable in a case where that guy gets his pension fund and starts squandering it all over the place. And I've seen cases in the Western Cape where it happened, where the ladies go to court and they inform the court, listen, this guy's going to get his pension fund. No, sir, we don't have a maintenance officer, or no, ma'am, we don't have a maintenance officer. In terms of Section 4.1 of the Maintenance Act, if there is no maintenance officer, there will be a prosecutor at that court. In terms of the NPA policy, Part 26 of our policy document, a maintenance of a prosecutor is deemed a maintenance officer. So there is no court in any court in South Africa that don't have a maintenance officer. So if a clerk or anyone tell you that there is no maintenance officer at the court, then you tell them in their face they're lying, because there will be a prosecutor at that court. If there is a prosecutor at that court prosecutor is deemed a maintenance officer in terms of Section 4.1 of the Maintenance Act. So when the lady comes and says, but please, we need to freeze the bank account, or we need to stop the pension fund from paying out, and the clerk says to you, no, there's no maintenance officer, then say, please let me see the prosecutor, because the prosecutor has to act. And that's what happened in Anna Mutimunia's case. Ms. Mutimunia came to court and they said, no, there's no prosecutor here. Eventually she came to a prosecutor. Poor prosecutor didn't know what to do and how to do it, because in terms of the NPA policy, Part 26 of the policy, the NPA prosecutors do not get involved so much in civil litigation. They focus on prosecution, Section 31, that's all we know. When we prosecute Section 31. Don't tell us about civil attachments, we don't know that stuff. That's how prosecutors think. But if a prosecutor prosecutes any matter and they get a conviction, then there are civil remedies that they can impose in terms of Section 40 of the Maintenance Act. So isn't it a good idea to rather learn now so that you know how to do your Section 40 and know your civil attachments and civil oaths? In Anna Matimuni's case, the poor prosecutor said, "You fuck, weet jy wat hier aangaan nie, mos by jy." So then the prosecutor will say, "Don't bring this to me, wait for the maintenance officer to come." And because of the period that had lapsed in between, poor Ms. Mutimunye didn't get her money. Guy bought himself a new Ford, Range Rover, Rover, whatever the thing is called, and was driving around while Ms. Mutimunye had to walk from USafe with the 2 packets of mealie meal that she could afford. And that's what happened. Luckily for Ms. Mutimunye, she had a family member that was working for the Department of Justice, and that person gave her the information on how to sue the Department of Justice. And that's what happened in this specific case. And Ms. Mutimunye was successful with her action, and she managed to get the full amount that was in her years from the Department of Justice and the NPA, because the NPA as well as the Department of Justice is jointly and severally liable in a case where they do not act on it. So the message I want to get out there is, whenever it is any type of retirement annuity or anything that you know is due and payable to that respondent, alert the maintenance office. If the maintenance office tell you there is no maintenance office, then you say, "Where's the prosecutor? I need to speak to the prosecutor." Part 26 of the NPA policy says that the prosecutor stands in a case where there is no maintenance officer available. So then you need to see a prosecutor. If the prosecutor don't act on it, Anna Mutimunye is your heaven. You will get paid out whatever the arrears is from the onwards, and make sure you know the specific case that is on the SAFMI. What you need to know is, whenever you do civil attachments, in most cases, there need to be arrear amounts in order to claim for the attachment of debt. So if you come to court and you say that I want to claim his pension fund, and the respondent all along have been paying his dues and have been paying the maintenance that is due to him, in most cases, the maintenance court will say, "No, but you've been paying, so what? What's your story? You can't come here with nonsense like that." In the Western Cape, in the case of Gerber versus Gerber, it was at last sorted out for maintenance applicants. There doesn't need to be arrears in order for you to claim in terms of Section 30. Why? We look at the Section 7 best interest of the child in the Children's Act. So whenever any doubt or there's any type of threat to the well-being of the child, then you can claim in terms of Section 30, even if there was no arrears. In the Western Cape, they said that no matter whether he was in arrears or not, even if he paid every single month, and that big amount that he is due can in any way jeopardize the future of the child in future, then we can attach it. Because what the guys do is, they get the big amount, but I paid all along, you can't take me to court, I've been paying all along, so therefore you can't do anything to me. Then they start squandering it. And then they go to the court, they complete the J107 and say, "I'm unemployed, I can't work, I can't pay this amount." But it doesn't say that he had 6 million in a fund that was available, as in Advocate Mohammed's case. In that specific case, Mr. Mavuza had 6 million rand in a fund that could have been used, but this was never mentioned in it. All that was mentioned was the reduced amount, so 1.8 million is all that is left over there. But the equity was 6 million that was there, and it was never made known in there. So what you need to do is look at the equity value of the retirement annuity, or whatever the case might be, and that is what you lay claim to. So what happened in Gerber's case is, Mr. Dale Gerber and Raymond Bryce Gerber, they were having this house together, and the house was sold. And during their relationship, or during their time that they were together, they were abusing drugs, or they were involved in different types of drugs. That was in the early stage of their relationship. When the case came to where there was this divorce settlement and a house in Gordons Bay had to be sold, then Mr. Gerber said, whoa, 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 please help me. I need to get the proceeds of that sale of the house in order to cater for the well-being of the children in the specific case. Mr. Raymond Bryce Gerber then said, no, I don't owe anything. I've been paying my dues all along. So how can you now want to attach something that is non-existent? Why are you doing this to me? Luckily, the Western Cape High Court said in that specific case, no, we don't work like that. In any case where there is any way that the material interest or the best interest of that individual child is in danger or at threat, in all of those cases, then you can claim for the retirement annuity or pension fund can then be claimed. The cross reference, the J470, you can find on page 47. A copy of the J306 you'll see on page 49. The affidavit that I spoke about earlier in terms of section 27, you'll find on page 63. And you need to be clear of how you calculate the arrears. So if you have an interim maintenance order and from last year October you didn't pay the 7,000 that you were supposed to pay and you only paid 1,000, you calculate all of those months. Just look specifically on page 64. There you'll see that column over there. What he should pay, what he paid, and what is the arrears. Include that in your affidavit so that the court can see how you come to that arrear amount. Once you show how you came to the arrear amount, then we will be able to see how to quantify the attachment that we need to do in that specific case. And as I said, best interest of the child, Gerber versus Gerber, the Western Cape unreported case is our precedent that we use. In case you struggle to get hold of the case, it's case number 12166 of 2007. If you struggle to find it, please email us at info@childmaintenance.org.za and we will send you a copy of the case for you to read and just to get that case. But Gerber versus Gerber makes it clear they don't need to be in arrears. As long as the best interest of the child needs to be protected, then that's what we will do. So section 30, anticipation or attachment of debt is what we can call anticipation interdicts. It's where we interdict the second respondent, which is the financial institution, where we want to stop them from paying out to the first respondent. And that is what we call anticipation interdicts. We dissipate, we think of what's going to happen in future. We know it might happen in future, therefore we dissipate that do not happen anti. That's why it's called the anticipation interdict. And the way we do it is that we will complete a form, and the form will then be the J306, and with the J306 we'll have a founding affidavit. With the founding affidavit, then we will either have our own NISI or not. In your notes, you will see that I included things. The Maintenance Act, somehow, when it went through these different stages in 1998, they were still didn't know how to do all of the State Law Enforcement Advisors somehow missed this thing, or they might have included it when it went in the Justice Portfolio Committee, they somehow omitted it. In the Maintenance Act, they say in the prescribed manner, but the prescribed manner is not explained anywhere in the Maintenance Act or in the regulations. You only find it in the Magistrates Court Act and the Magistrates Court rules. Luckily for us, in terms of section 46 of the Maintenance Act, in a case where the Maintenance Act is unclear or silent on any matter, then the Magistrates Court Act and the Magistrates Court rules are applicable in terms of section 46 of the Maintenance Act. So there is a way that we can deal with it. Since the Maintenance Act doesn't have the prescribed manner, the prescribed manner we'll find in Rule 55 of the Magistrates Court rules, and that's how we deal with cases. So J306, your founding affidavit, and in some cases you will have what the courts will say is a notice to the respondents, The notice to respondents is then done in terms of the Magistrates Court rules. There's a case that came out 2 weeks ago, VDB versus VDB. In that specific case, it says that it is not a right for a respondent to be getting notice, because some respondents say, I didn't get notice, why are you taking my money without even informing me of it? Luckily for us, except for the VDB case, there is a new provision in the Maintenance Amendment Act, section 26(2)(dd). If you look at that specifically, you will find that in a case where it is detrimental to the well-being of the children, then there is no need for the court to give notice. The court can act immediately. In most cases, magistrates will not do it. Magistrates' court do not want to deal with the case unless there's notice. But the Maintenance Amendment Act 9 of 2015, section 26(2)(dd) says that in a case where it's detrimental to the specific applicant and that the remand will be unreasonable, in those cases the court can give an immediate order. There is a J538 or a 548 document that can be completed by the respondent in a case where the respondent wants to rescind that specific order. So there is a recourse for the respondent. So it's not as if he's saying, can't do this to the poor man, he must have some recourse. There are recourse. J438 and J538, those documents can be completed to apply for a rescission of the order that was made by the specific court. So there are different types of recourses, but the Maintenance Amendment Act and VDB versus VDB, those cases says the court can give an immediate order. It's not necessary to give notice in all cases. And the Gauteng High Court now made it clear the respondent is not entitled, it's not a right. It is what is in the best interest of the children. And these things that cases are remanded in certain courts must go here from October till May. There's no way any court can remand a case for 6 months for you to get a civil attachment order. That's unfair towards that child. And the Maintenance Amendment Act should have been known to the magistrate. Section 10(6) says you limit the number of postponements and the duration of the postponements. You cannot have a case being remanded from October to May of 2022 from last year, 6 months. Whenever you get any of those type of cases where cases are remanded for such long periods of times, you will have a right to complain against it. And please, I'm asking you, you do complain and you ask that that specific decision be taken on review, because it's not an order. It is just the court will give a remand. Okay, we'll remand the case till May next year, or in May, 30th of May, they will give a case and remand it till September. That is unfair in terms of section 10(6), that the case be remanded so long, and VDB versus VDB is clear. It's not a right that the respondent should be notified. Ex parte applications is allowed, and there are recourses in the Maintenance Act that provides for it. So there's no reason why a case should ever be remanded for such a long period of time. So if any case is remanded for such a long period, just tell them, Your Worship, but doesn't section 10(6) say that you can't remand the case so long? They usually will make you quiet and say, go back, keep quiet, you don't speak over here. If that ever happens, then you take them on review. Do not sit still and think, okay, then I must wait because, can't speak, you must keep quiet. Do not let you be silenced. Because if you're silenced, your child is being silenced in the process. And that is the reason why the Maintenance Amendment Act 9 of 2015, section 26(2)(dd) have been implemented to make sure that these type of rights of our children are being protected in law. I don't have time to explain Ngadi versus Beacon Suites. I will, hopefully towards the end of the year, explain all of the most necessary cases. Ngadi versus Beacon Suites, I will explain. Advocate Mohammed also was involved in the Nancy Soller case. Solar versus Magistrate Weinberg is where Ms. Solar took on the authority or the jurisdiction of the maintenance courts, and maintenance courts is use only millions. You know, we can't take millions. We are a creature of statute. We can only work with 100,000, 200,000. We can't work with millions. And luckily, in the Solar case, Judge Lope put it right that we, from now on, a maintenance court, even though it's a district court, can even attach 6 million or 20 million. There's no stopping us when it comes to the maintenance court. If there's one thing that you take home today is maintenance courts have no any limitation on their jurisdiction. They can attach 6 million, 20 million, whatever the amount is, in terms of the Nancy Solar versus Magistrate Weinberg case. I give the citations. All of it is on SAFLI in case any of you need any of these cases. If you can't find it, register on info on the childmaintenance.org.za website, and in the library you will find the Nancy Solar case as well as the Beacon Gardy case, those two cases. Gerber versus Gerber, I mentioned a little bit earlier too. And then all you need to know is in a case where you are applying for future maintenance, that in those specific cases, no matter what the amount is, you will be able to claim it in the maintenance court. You do not have to go to the High Court to get any of these type of orders. What is important that came out in the Solar versus Magistrate Weinberg case is the paramountcy of children in terms of Section 28(2). And why are we doing it? Because the preamble of the Maintenance Act says that we need to give strong measures or have strong measures in place to ensure that maintenance is paid. That is also said in Bannatyne. Bannatyne versus Bannatyne, Judge Yvonne Mokgoro said the same as in the preamble of the Maintenance Act. So I'm not going to go into any of that. So what you need to know is the process. So ex parte application, the ex parte application, room nisi might be given. In most cases, the magistrates want a room nisi. It is not a right in terms of the Maintenance Amendment Act. In a case where it is a Section 28 order and you want to do an attachment of emoluments, it can be immediate. If it is a Section 27 or a Section 30 order, that's where you need to notify the respondents, especially financial institutions, need to be notified because they, in terms of the Maintenance Act, need to give notice and say whether they are actually that money. There's no use you attach a respondent's money and then you find there's no money in the GEPF or in the pension fund and the money have already been paid out. Then it's unnecessary to attach to a respondent that don't have the funds. Then you look for where the funds are and you will then freeze that specific account, like in the GPF versus Besaidenout matter where it was dealt with. The other case law that you can have a look at, it is on your handout, so please have a look at it. These are the sections that I spoke to about in the Maintenance Amendment Act. Section 16.2 DD, I said Section 26, Section 16.2 DD, and Section 28.1D of the Maintenance Act are your authority that says that in a case where a postponement will be detrimental, you do not have to give notice to the respondents or to the employer in those specific cases of attachment of emoluments. In your affidavit, give as much details as what you have, even though you don't have all the, if you know the retirement annuity, just say that while we were together, he told me about a retirement annuity. Investigations must be done by the maintenance investigator, Michelle. Section 7 is clear. In those specific cases, you can request, and look how I drafted that affidavit in your notes. If an ITC investigation has been done, this will be revealed. If they do a proper investigation, they will find out that there's a retirement annuity registered on his name. And that's how they will be able to get all of that information. And then use Advocate Mohammed's case, that if a proper investigation is done, then all of these things will be revealed. And as what Peter said earlier, in your case it's a reduction, so now you have to show good cause. He must show good cause. You say, where's the good cause? If he's got a retirement annuity, Means is not just the mere fact that he's earning a salary. Means is any other type of asset that he might have that can be liquidated in order to make sure that the children eat. Not for him to keep a house in Plettenberg Bay while the children are suffering over here without food. So use all of that information that you have available of cars that he might have, because then we can do what we call an e-notice to see what cars are registered in his name, an ITC to see where he bought on credit. And if we find out that he bought on credit, we can always subpoena that credit agreement, because in the credit agreement, he will make himself, you need to show somehow that he can afford it. Then, in the maintenance code, he says, no, I can't afford this, I don't earn that much, I'm only earning 10,000. But when he did the credit agreement to buy the car, all of a sudden he's got 58,000 rand that he's earning. So if you compare the two, then you will start seeing the disparities. So I'm telling you, get the ITC, once the ITC is there, you'll find out where he got credit or applied for credit, and then you subpoena those credit agreements. I did it in the case in Vredenburg. And then, lo and behold, we found out that the respondent used the name of his uncle in order to get the credit agreement. But then we found out what happened or transpired between him and the salesperson. And then we attached a bucket, even though it was registered in somebody else's name. We call it lifting the corporate veil. As soon as you lift the corporate veil, then you will find, oh, it's actually you over here and not the uncle or whatever it is. So there are ways and means that we can do it, Michelle. In terms of Section 7, if the maintenance investigator do what they can, Advocate Mohammed put it so nicely, he's the sheriff. The maintenance officer is the sheriff with all the guns. And they're not using their guns. They're sitting with the full artillery with them. And you have to wait and see what... The one that you want to use is the Poppy Act. They say, no, we can't go into these people. People are going to sue us because of the Poppy Act. The Poppy Act is only applicable in a case where it is not of a lawful nature. In a case where it is of a lawful nature, in terms of the Maintenance Act gives the maintenance investigator the authority to do it. So they are acting in the lawful means to get that information. So there's nothing that stops us. Not even the Poppy Act can stop us. Section 103 of the Poppy Act is not applicable when it comes to maintenance matters. It's not applicable. If you know the Poppy Act and you know how to counter it, then you will see that the maintenance investigator in terms of Section 7 have the authority to investigate. Even if it's a third person, where he goes in the new lover, they usually hide it away. Sweetheart, you must keep it now. He's fucking so you keep it there. So that's where they usually hide it. So to make sure that we go and get that, we left the corporate veil, and lo and behold, Mommy never knew anything about the taxi business. She don't even know how to drive, but she's the owner of the taxi business now, because now he needs to get all of the stuff registered in a third person's name. So when all of those things happen, Section 7, they've got the authority to do it. And the case that, the Eastern Cape case that Advocate Mohammed mentioned, that is our authority that we can now make sure that the proper investigation has been done before the court comes to a decision. If it is a reduction application, make sure that he shows good cause and that they know about his retirement annuity and all the other things that you knew while you were together as a couple. You know things. You will buy, sweetheart, I just bought a new thing. All of that, make note of it. You don't know when you're going to need it one day. Make a note with the donor, a note. Because one time or another, that is going to be your artillery that you can give to the maintenance investigator to do his proper investigation. Well, oh, okay, then he actually did have it. But now it's not in his name anymore. It's now in the sweetheart's name. The sweetheart is now in charge of all of it. She has no idea. Undue enrichment, she's unduly enriched at the cost and at the behest of the minor children. And that's how we will deal with it. So give as much details as possible in your affidavit. Felicity mentioned this, and I'm not going to repeat it. Keep proper record of whatever you do, who you speak to, who's the maintenance clerk that you spoke to. Ask them for their names. They're supposed to have name tags. None of them have the name. They forgot it at home. But ask them for their names. Whoever you spoke to, when you get to the court, take a picture of that notice board, Because one time or another in the next 18 years that child is alive, you might need it. So keep it for record purposes now already, then you know you've got that. Follow up at least once a week on the progress of your case. If you're not in Natasha Stovall and in their faces, they will forget about your case. But as soon as they say, yes, I'm very fucking wrong, then they will quickly help you because they don't want to deal with you. They don't want to deal with the Corniers and the Stovables because they don't. It's moeilikheid wat weer kom, sy gaan nou weer gaan klaar. As soon as you're in their faces, then they start taking you serious and then they start doing what they're supposed to do. Because they want to get out. And the court manager says, kry die vrou hier uit, laat sy net klaar kry. If you complain, you become actually like a royal highness. When you come into that court, they want to help you first because they know your mouth is going to be big and they don't want that attention. They want to make sure that they want to deal with it. With those ones that just come for a date, court date. What are you over here for court date? August. You come back August. They're quick to give dates and not deal with the case. But as soon as you start throwing your toys out of the cot and saying, who's the court manager? I want to file a complaint. Who's the regional court manager? I want to file a complaint. Who's the regional head? I want to file a complaint. You will see how quickly they help you to get you out of there because they know there's trouble coming. And as soon as you start complaining, and it's unfortunately the South African system and the way we deal with things, we're supposed to be moving towards a first world country where these things just happen. It's supposed to be our rights and it's supposed to just automatically happen. That's why we've got this J306. We have to enforce our rights. It shouldn't be like that. We shouldn't be enforcing our rights. It should come automatically. In a case where he doesn't want to pay, then he should be put in front of a court. Police don't know Section 305(4) of the Children's Act that says where a parent do not comply with his parental duties to make sure that there's enough food and clothing. Why must a woman complain 6 months or 10 months and then still don't get any joy out of the system? They must first get a maintenance order. Why can't we file criminal cases and get the guy on a criminal case in front of the court, even though there's no maintenance order? 305(6) says they can go to jail for 10 years. So let's start getting these cases to the court system. 305(6) of the Children's Act at the end of 2005. Section 305(4) of the Children's Act says a parent can be held liable even if there's no order. 305(6) says he can go to jail for 10 years in a case where he's found guilty. But none of these things ever come through the court system because no one of us are willing to take these cases on. Or the police want to keep their stats. Go to the court, go sort it out to the court because they want to keep their stats low and make sure that they look good. This is a police station that takes care of their cases, investigate their cases. There's no crime over here. But those silent crimes or financial abuse is not being exposed. Those ones are being thrown under the carpet. The station commander said, dealing with this with me. Get the details of the station commander. They don't want to take your case in terms of Section 305(4) of the Children's Act at the end of 2005. File a case against them because the charge office of the police have an orange file in the charge office or child care. In that file is a document that they call a standing order 3 of 2010. In that document, it says that this is a crime, but no one will ever deal with it. There's no single case in South Africa dealing with Section 305(4) of the Children's Offence of the Children's Act, even though it's an offence, even though there's a 10-year penalty, nobody do anything about it. But hopefully, if you take the message out there that you can file a case, on the library there is those affidavits and examples of how you can file a case in terms of Section 305(4) of the Maintenance Act. I already mentioned all of these. In a case where you've got your emolument attachment order done and the employer do not comply with it, if there's non-compliance, then we can prosecute the employer, or else we can attach his bakkie or his cars or whatever because he didn't listen to the emolument attachment order, the garnishee order. So if I do not pay my maintenance and it is served on the NPA, and the NPA do not deal with that emolument attachment order and start deducting, then there's nothing that stops the applicant from attaching the MPA's bakkies or cars or the NPA's bank account. That's in terms of Section 29(4) of the Maintenance Act, and there's a form that is completed. It's called the Form L. You just complete the Form L and you then use Section 29(4). So any employer that do not want to honor an emolument attachment order, we deal with that in terms of Section 29(4), and then we can also file a criminal case in terms of Section 38 of the Maintenance Act. The Section 27 attachment of assets, usually when you want to get the assets attached, the sheriff put a security fee to it. That's nonsense. In terms of the DOJ Code, paragraph 40.1.5, it says that the Maintenance Court or the Department of Justice can deal with that security fee. They can pay for it. So the DOJ Code says even the maintenance investigator is supposed to assist the lady when she have an attachment of assets. So when you go and attach the car of him, that car needs to be attached. The sheriff will take hold of the car. The car will be stored in the garage or at the sheriff's property, or wherever there's a safe place to store that car until the auction. So what happens is the sheriff will say, no, I need to ask a security fee to store it there. But that security fee can be paid by the court in terms of the DOJ Code 26 of 2015 in terms of paragraph 40.1.5. The Sheriff's Act in Rule 38 says that the sheriff only need to ask a security fee in a case where there is actual, then they can ask a security for it. It's not necessary in all cases that the security fee should be asked. So Rule 38 is clear. It's only in the case where they're unsure whether they're going to get their money or something's going to go wrong that they ask for the security fee. If they know where the lady is staying, if they know where the person is staying, if they know there's assets that can be attached, it's unnecessary for the security fee that is attached or being requested by the sheriff. So in a case where the sheriff do ask for a security fee, please then you can file an affidavit, and in your affidavit you say that you can't afford it and you want the court then to assist you in that case. Look around page 63 or 64, there is an example in your notes how to do that. So Section 30, attachment of debt. In that specific case where it is a financial institution like Alan Gray, I almost said Alan Ford, Alan Gray, or any of those type of financial institutions, in those cases you need to give notice because they need to tell us whether there is actually money in that account. So VDB says you don't need to give notice, as well as the section or the Maintenance Amendment Act 9 of 2015 says that we don't have to give notice. But when it's attachment of debt, then the financial institutions need to be notified of our action so that they can give information to say whether there is actually money in that account. Because it's no use we sue Alan Gray and say Dionitis has got an account and Dionitis never ever had an account there, then you're wasting time. So that's why in certain cases there need to be a notice given. A NISI application will then be done, but as VDB said, it's not necessary, it's not a right that all respondents need to be made known in all cases. Future maintenance, whenever you deal with future maintenance matters, you can calculate future maintenance up until the age where the child is 18 or even 19. Whenever I deal with future maintenance, I calculate an amount of money up until the age of 19, just in case he fails one of the years because of whatever happens, and I can explain to the court why I'm including an extra year. As soon as he becomes 19 and he's got a propensity for tertiary education, you can make a provision for it and just keep another amount somewhere in the guardian's fund. Let me just keep an extra $1 million of his money just in case the child wants to study, then there is money. So all of those things you can provide for in the future maintenance orders. I did one matter in Stellenbosch where a father came to me and voluntarily surrendered his retirement annuity. I spoke to my wife about it and I wanted us to interview him and maybe we can see if we can't get an interview with him and deal with it where he explains why he wanted to do it. So there are good guys out there that are willing to surrender their retirement annuity in favor of the child. And I went to Stellenbosch and I managed to get the Stellenbosch court to give a Section 30 attachment of deed where there's a voluntary assignment or voluntary rendition where the respondent voluntarily agreed to us attaching his retirement annuity. So there are some of these good guys out there, and I would like to maybe in the month of August, when it's Women's Month, to see if we can't get him over here, or else just have an interview with him where he tell his story and why he surrendered his retirement annuity. And he gave me all the details of Alan Gray Investments, free advertisement, good place to have your money invested in. The legal officers over there are on the ball. When I got the details, they said, no, don't even give notice, just get us an order. Once we got the order, we do it immediately. I went to Stellenbosch Court, the Chief Magistrate, Maya Parak, quickly got the order from Magistrate Parak, thank you, Ms. Parak. And from there onwards, I managed to serve it on Alan Gray. And within 48 hours after I served it on Alan Gray, it was paid out, and the child's full expenses at a private school in the Western Cape was paid in full. And there was an extra amount. Alan Gray called me and said, listen, don't you want to cover for his registration for the following year, since there are money available? So my hat's off for Alan Gray. So please, if you ever want to invest in a good financial institution, free of charge, Alan Gray is one of the ones that I will recommend. Okay, Section 26.3, that's the authority to do future maintenance matters, and how you will then deal with these matters. Section 26.3, the reason why I put it in here is because you need to choose in which lane you want to be. If you have a emolument attachment order, you can't have a future maintenance order also. So that is why I put Section 26.3 in here. I want to explain it again. If you have an emolument attachment order, you can't have an attachment of assets in terms of Section 27 or Section 30 attachment of debt. You need to choose one or the other. If you have an emolument attachment order in terms of Section 19, it must first be cancelled before you can get an attachment of assets or a Section 30 attachment of debt, a retirement annuity. Marie, do you understand? Or, because it seems as if I just got you off track with it. But just give me an opportunity. I'm almost done, then I will give an opportunity to ask questions. So, in a case where you've got an emolument attachment order and you know that he resigned, then go to the court and ask the court to first cancel your emolument attachment order, then bring a Section 30 attachment of debt order, because you can't have an emolument attachment order in terms of Section 26, 28 and Section 16(2) of the Maintenance Act, and then also have a Section 30 attachment of debt. You can't have two. You must have one of them. That is why it says that in that case, the court cannot authorize the issue of a warrant of execution where there is a Section 16(2) emolument attachment order. It's technical, but I wanted to put it in here so that you know about it. If it happens, ask for Section 19 cancellation of the emolument attachment order, and then you bring a new application in terms of Section 30 for the attachment of debt. I quickly just want to deal with the phrasing of a bank account. So whenever it happens that there is money that is due and payable to the respondent, I always ask the maintenance officers to have the respondent, if you have his bank accounts, use the bank where he is banking as a second respondent. Why? Just in case the third respondent, the financial institution, Alan Gray or the GPF, Government Pension Fund, already paid out to him, then it will pay out into his bank account. That way, we cover on both sides. So if it is that the pension fund says there's no more money there, we already paid out, then we cover it in the bank account on the other side. And that's why I always recommend that the bank where you bank is also cited as the respondent, just so that we don't have to bring another application, another exercise, another rule, you see, just to make sure that all of that is in there. And remember, time is of the essence. We need to act fast in order to then get that done. The procedure is simple: J470 complaint form, your J306, your affidavit, and then all of those go to the magistrate. Magistrate court, one day will miss it, you give notice. Your notice period will usually be 14 to 21 days, and then notice has been given. In most cases, they say that it must be served on the respondents personally by the sheriff or by the police. Please try and get a copy of that order, because Regulation 26 says you can fax it. I recommend to most applicants, just get a court order and go to CNA or PNA or whatever NNA it is and fax that damn thing to them, because Regulation 26 says they must just get notice of it. So if there's any problems, then you can say, no, but it is fax, they must just go and check their faxes, because maintenance officers or the whole system is rigged in the sense that they want to first give it to the sheriff. The sheriff will then take his own time to go and serve it on the respondents, and then the sheriff still come back with a nulla bona. That means they didn't serve it on him. So now there must be another service happening. But if that thing is faxed to them, and then you call the manager or the CEO and ask, listen, did you get a fax? And if what's a kakasdi? That's all you need to know. But from there onwards, you know that at least they know they received it. Then you can draft an affidavit, and in the affidavit say, no, but I faxed it to them. There's nothing that says you can't fax it to them. Say Regulation 26 says it can even be faxed to them. And they confirm they received it. What you want is notice. They must have notice. They got notice. They said, so that's your notice. And that's all you need to do. From there onwards, you've covered yourself as far as that is concerned. So then you know that all your things is in order. You want your order. Because the maintenance courts recycle these things over and over and over. Remember how, let's give another date. Next time we'll get him. We will serve it on him personally, or we will serve it on a person over the age of 16. That's what they will tell you. But just make sure that there is notice being served. If they don't do it properly, and they didn't use the police or whatever the case might be, please, if it's in the Western Cape, notify me, and I will deal with it. I get things served immediately. The provincial police, I've got friends in the provincial police, and that's the nice thing about being at this office. If I said to the provincial commissioner, please help me to serve this, the PA of the provincial commissioner is a friend of mine, instantaneously, within 48 hours, it will be served, and it will be where it's supposed to be. If it's in the Western Cape, if it's in the other provinces, unfortunately, I have to struggle with you. But let's struggle together in order to get that thing done. And that way, make sure that these orders are served on the maintenance courts. If you need to speak to myself, that's my email address, or else on info@childmaintenance.org.za, you can then put if there's any complaint, or if you need assistance, please let us know. Or else speak to my colleague, Ms. Nokwanda Rosani over there. She's in Wynberg, and she can help you with any case that involves Wynberg if you need some assistance. If there are any questions, now's your time that you can ask any questions. But when you leave, please can you support and buy an apple at the cafeteria, because my colleague made the cafeteria available so that all of us can at least have a place to sit and a place to smoke, and that's why I managed to get that. You had a question for me? I forgot.
Yeah, so to be confirmed, so you're saying that I'm not going to be feeling.
Yeah.
So if I go, if I just hand in my affidavit, and then they must do the investigation.
Yeah.
And then once on the findings of the investigation, it's to be cleared to both of us, to all of us.
Yeah.
And then go in with whatever.
Yeah.
If there is an order, if there is
Yes.
the asset, and then.
Yeah.
But the question I have is actually on the asset. If the asset sheet, it's not only co-owned.
Yeah.
does that close up another aspect?
Yeah, it all depends. Say again. Okay. The question is, in her case, is she the respondent or what is it? You are the respondent in that specific case because he is applying for a reduction. So when he's applying for a reduction, you will then automatically become the respondent. You respond to it. Your question is, in your affidavit, you put all of that in and do they do the investigations and then on the day of the inquiry, then we'll give all of the results of the investigations. Yes, that is what will happen in all of those cases. But what I recommend is you file an opposing affidavit. I oppose it because I know he's got a retirement annuity, he's got this, and therefore I would like them to investigate this because the e-notice is going to show how many cars he's got, the ITC is going to show where he did all his credit agreements, and all of those things is going to be revealed. And remember, he must show good cause. If he shows good cause, then obviously that will be what needs to be proven in that specific case. Ms. Haas? Yeah. Sure. Yeah. Okay. Excellent. Sure. Yeah. The question is, in a case where is it necessary to have both the work address and the residential address? One of them, if you have the work address, that is sufficient. That's why the Maintenance Amendment Act says that now you can file your case where you work or where you stay, whatever is convenient for you. So he needs to provide those addresses to the court, and it's a criminal offence where he doesn't provide it. So when you sit in the next meeting, then you make it known that he is not giving his address, or the address that he gave last is the address of the girlfriend that he is staying with now. But you want to know what is his physical address and his residential address, and that, or his work address, so that he can be served properly. And he needs to make that disclosure to the court in order to make it clear to everyone. Rosani?
Sorry, just on that, why are we not seeing criminal charges
being put?
Yes. For people that change addresses and obstruct justice intentionally?
Because most applicants do not know about it, that they can actually put a charge like that or complain that he doesn't want to give his charge. It's more work for them, and
that's a pathetic excuse. I'm sorry.
I agree with you.
I'm just saying, why is it there's not a single person that I'm aware of that has
been prosecuted
for that, for perjury, for any of those, and those should be automatic charges.
Yes.
Because if we put that in the press, then we will have less of that behavior.
Yeah. That's why I say that we need to get more of these type of cases out there, and where we in the affidavit ask and recommend that he be prosecuted for not providing his address or not making known in the reduction application on his J107 that he actually have a retirement annuity that can be liquidated in order to make money available for the best interest of the child. All of those things is supposed to be made known to by him during the inquiry. Ms. Ars, can I quickly just give one of the others also an opportunity? Ms. Nakwanda? Wow, okay. How many is a number?
I find it being a challenge for Jay to explain for most applicants.
Yeah.
I just need to know if there is a specific time that this application should be done with that step.
Yeah.
Because, for example, there is a letter whereby an applicant came to court and informed us that the respondent
is for him to receive his pension funds soon.
Yes.
So now, what is the procedure after she has applied, made this application?
Yes.
And then when I take it to court, I see, oh, she has completed everything, but then when I get there, the magistrate is not taking about something on the application.
Yeah.
She's been completely correctly, whereas I saw it, there's nothing wrong.
Sure. Yes. Okay.
And yeah, so how long should that take?
Sure. I always tell people, make sure that you do it, or you can show what you've done. And in the case where the magistrate query anything, let her put it on record. In terms of section 42, there must be proper record. So she must say on the 28th of May, maintenance officer approach court for a section 30 attachment of debt because the pension is going to pay out. There must be a record of it. What the magistrates do is the magistrates want to do these things in chambers. No, you can't do this. So there's nothing on the record showing that you brought the application and it was turned down. So it looks one-sided as if it is only you that are somehow stopping it. So what you then do is you go to the magistrate in chambers and ask her to please put it on a record. This is what you've done and this is how you wanted to do it. Makwanda, can you keep your other questions for a little bit later? Then what I will do is you and I can I'll deal with that a little bit later. Just want to give the other lady also an opportunity. Sure. Sure. Okay. Sure. Okay. Okay. Yes. In a case like that, what you do is in terms of section 9.2, you summon all of them. They must come and say what is their involvement in the company, what is their contribution, how much did they actually contribute to the company. Then based on that, if you lift the corporate veil, you will see what is his contribution to it. Say his contribution, or it is him and 3 of his cousins, then it is 33% each. Let's just argue on that. Whatever the income of the company is, say the company made 20,000. Of the 20,000, at least 6,000 goes to him. How much is your maintenance order? Based on that, then you can lay claim to whatever is his value in the company. So what you will usually do is you will look at how many people are in the company, ask the maintenance investigator to summon all of them, let them come and testify under oath. What did they contribute to that specific company? Once it comes out how much they actually contributed, I didn't give anything, I was just told to give my name to be on the board. And then you see that actually they are unduly enriched at the detriment of your child. Then you can say, no, but then in this specific case, he's a silent member, is supposed to have a 0% interest. The actual person is the respondent that is having all the, but that's part of the investigations. If the investigations is done properly, then all of those things will come out during all of that. Natasha, and then Peter, and then the lady up there. Yeah. No. We can, but it's a difficult procedure that needs to be followed. Because of jurisdictional issues, it will be difficult. But there is a provision in international cooperation in matters where it can be done. But that process is long and tedious. It's going to take anything between 6 and 12 months to sort it out. But it can be done. And it all depends on the other authority in the other country. Like Facebook is going to say, yeah, I'm not going in, giving anything. Then you have to fight it in the jurisdictional country, United States, in order to get what you want for them to make those photos available of him going to the Bahamas or whatever. So in all of those cases, it is difficult, but it can be done. Yes. Yes.
Now, if the HR says, no, sorry, we just the third person, we realize, God, we can't do anything.
Yeah.
Then what is the recourse? Do you still do the attachment?
Yes. Yeah.
The same, so it's
yes.
to you, and then what period do you cover?
Yeah. Okay, whenever emolument attachment order is given, there's a form that goes to the employer. It's called a Form O, Notice to Employer, it's a J448. The J448 is then served on the employer. On the back side of the form, there's a Part C of the form. Part C says, in terms of Section 29, you need to inform the court as soon as this person leaves your employment. If you don't, you can be held liable. It's in a red warning. If you don't do this, this is what's going to happen to you. So, in terms of Section 29(4), you can then sue them for not informing the court for any arrears that have accumulated from the date that he resigned from the company and they didn't inform us. If his pension fund or whatever was paid out, you can still claim it from the employer, because the employer has a duty in terms of Section 29 to complete that J448 Form O, Part C. If you didn't complete it, then you have a legitimate claim against the employer. You and then the lady at the back. Yeah. They don't have a right. They need to investigate, and especially in your matter, and if there are children involved, they need to investigate. If they don't, and as I said over there in that slide, follow up. If nothing has been done, then you send it to the court manager, the area court manager, and the regional head. Send it to all of them at once and complain to them and say, listen, this is what is happening, and if nothing is...
Please be patient, Ms. Hill.
Yeah.
Be patient.
Unfortunately, we know which court it is, and we know what's happening to that court, but the thing is, we need to nag them. That's the only way you're going to get somewhere. And if you're not happy, Ms. Hill, then you go one step higher. The provincial authority is not the only authority. There's a person sitting in Pretoria that is the Director General Court Services. Get his details. Ms. Stobel's got all the details. You can ask us. He's got all of it. Say again? Yes, escalated to a higher authority if you exhausted the provincial authority and they didn't do anything. And time is of the essence. You need to move on. Because your case is so long on the portal. It's more than 40 days that Jesus was in the desert. So just imagine what would have happened to that child if the child was in the desert by now. Then the child would have died by now. So go to the next level. You've exhausted the court manager, area court manager, regional lead. So now you go to the director court operations in Pretoria. Says who? Oh, okay. No, but the thing is, he can't tell you what to do. Do what you need to do. That's the best. You need to do something.